Good morning to all. We are entering into the second day of training. So I think you get to know about some of the provisions of BNSs through the training on aesthetic. Let us proceed with same vigor. Let us continue the discussion mode we had on aesthetic. So we are a bit late, so we have to go. We have to proceed fast. So that said, in introduction, I request our Honorable Resource Person, Honorable Mr. Justice Narayana Pishardi, to commence the class straight away.
Good morning to everybody here. Before entering into the main topic today, I will bring to your notice one thing. Day before yesterday, the Ministry of Law and Justice has issued a notification which states that in all other acts, wherever CRPC, IPC, and Evidence Act that expressions are used, they will stand replaced with BNSs, BNS and BSA. For example, in BNS Act Section 37, bail, notwithstanding anything contained in the Code of Criminal Procedure, this starts with, as per this notification, we have to read it as now, notwithstanding anything contained in the Bharatiya Nagrik Suraksha Sanhita 2023. Not only in all acts, but all ordinance, regulations, everything. Now, we start with trial before a court of session. Section 250, subsection 1. That is a new provision. The accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under section 232. Under the code, there was no specific provision enabling an accused to file an application for discharge. Though the practice was that the accused may file an application. Accused could file an application. Now, statutorily, it is provided that he can. But see, the provision has got some practical problems. The period of 60 days, that has to be reckoned from the date of commitment of the case. See, date of commitment of the case by the magistrate. Thereafter, after commitment of the case, the records have to reach the sessions court. The sessions court will verify the records. Then, after numbering it, if the accused is not in custody, summons has to be issued for appearance before the court. All these process may take some time. So it will be very difficult for an accused to file an application for discharge within a period of 60 days from the date of commitment of the case. That may not be possible in all cases. So that is a practical reality. And The Supreme Court has recently held that in a sessions trial, the accused has to be given sufficient time to engage a lawyer and for preparing his defense and to argue for a discharge. Sufficient time should be there. Now, this provision will not enable the accused to get sufficient time for filing an application for discharge. The decision is, you may read regarding other aspects also, that is a very interesting decision, useful decision, that is 2024 KSC Online 6309. 2024 KSC Online 6309. That is Supreme Court.
That's a good decision also. Many practice directions are also issued in this decision.
Sunita Devi, SUNITA. TH വെച്ചാൽ കിട്ടില്ല, അതുകൊണ്ടാണ് പറയുന്നത് പ്രത്യേകിച്ച്. SUNITA. Sunita Devi versus State of Bihar. It was a case in which a POCSO case was, I think, if I remember correctly, tried very quickly, hastily, and the conviction was ended. Supreme Court set aside. No sufficient time was granted to the accused to prepare his defense even. And everything was done through this video conferencing. In Bihar, there was some rules as in our state, and it was done taking advantage of those rules. And the Supreme Court set aside and remanded the case, I think, if I remember correctly. No.
When a retrial is possible in a criminal case is also lucidly stated.
Many aspects, practical aspects mentioned there. That is why I stated that decision. Then, see, suppose this time limit is not complied with. Accused is not able to file an application for discharge within a period of 60 days from the date of commitment of the case. What happens? Will he lose his right to raise a plea for discharge? Will he get another opportunity for raising a plea of discharge? Okay? Framing of charge. Before that,
there shall be a hearing.
Accused has to be heard. And if necessary, accused can be examined also at that time. At that time, he gets an opportunity. He can make oral submissions. I am entitled to get a discharge. Now, suppose he doesn't make any plea at that time. No application is also filed. Suppose the materials produced by the prosecution do not disclose an offense. The accused has not raised any plea of discharge. The accused has not raised any plea of discharge. Can the court frame charge? Can the court frame charge? No plea raised by the accused for discharge at any stage. But it is a case where the offence is not disclosed or prima facie there is no ground for framing a charge. The prosecution materials do not make out an offence. Can the court frame a charge? Court can discharge. Can the court frame a charge? That is my question. Court shall not frame charges if that be so. It is a duty of the court to peruse the materials and find out whether there is sufficient ground, in spite of whether there is a plea or not. And 2 days back, the Supreme Court has held that if there is no legal evidence, then framing of charge would be groundless, and compelling the accused to face the trial is contrary to the procedure which will offend Article 21 of the Constitution of India. 2024 KFC Online 6368. 2024 KFC Online 6368. Now, section 251, subsection 2, where the judge frames any charge under clause B of subsection 1, the charge shall be read and explained to the accused present, either physically or through audio, video, electronic means. So, charge can be read over to the accused and explained to him even through electronic mode, electronic means. Then, suppose he pleads not guilty, and suppose he is on bail, right? How will the plea will be, or that memorandum plea of not guilty, that will be got signed from the accused? പ്ലീ വായിച്ച് കേൾപ്പിച്ചത് മറ്റേ വീഡിയോ കോൺഫറൻസിംഗ് കൂടിയാണെന്ന് കരുതുക. എങ്ങനെ പ്ലീ റെക്കോർഡ് ചെയ്തിട്ട് ഇത് ഒപ്പിട്ട് വാങ്ങണ്ടേ? How can it be done then? If he is in custody, there is a provision. ഇത് എവിടെയെങ്കിലും പറയുന്നുണ്ടോ പ്ലീ റെക്കോർഡ് ചെയ്ത് ഒപ്പിടണമെന്ന്, അക്യൂസിന് ഒപ്പിടണമെന്ന്?
Anything from your side? This is a very interesting question. Anywhere it is stated, the accused has to sign in the plea. Rules of practice ile എവിടെ പറയുന്നു? Rules of practice എവിടെ പറയുന്നു? Plea ആണ്. Not that something in the deposition of or written statement of the accused. With regard to framing charge, We know that it's in vogue, it's in practice, but where it is stated, legally stipulated.
Definitely, it is an accepted practice. Anyway, unless this can be brought within the purview of examination of the accused, the expression examination of the accused, there is no other provision, I think. If it can be considered, the recording of plea can be considered as an examination of the accused, there is provision. It is to be signed. Now, now,
But any counter view? Eh? Anyone has got a different view? Where it is stated that the accused has to sign on the plea of framing charge. His plea and his claim to be tried is to be signed by him.
anyway, he cannot later dispute if it is true audio video electronic means, because it will be a recorded. That is one thing. Anyway, that is recorded there.
We are getting it as is impremature. It's if it is recorded, what else is required? Other that is subsequently there.
Then
ഇപ്പോഴത്തെ 360ന്റെ പരിധിയിൽ വരുന്ന ഒരു എക്സാമിനേഷൻ അല്ല. അപ്പൊ അതിൽ വന്നെങ്കിൽ മാത്രമേ that is corresponding to.
That is a debatable point. That is a debatable point. Whether it will, that is why I said only it can be brought within the expression examination of the accused. Then
പഴയ
it will be
ഇപ്പോഴത്തെ 360
it will be subject.
പരിധിയിൽ ഈ ചാർജ് ഫ്രെയിമിംഗ് പറഞ്ഞിട്ടില്ല. That may be the reason why a separate provision is not incorporated there.
Suppose the court frames a charge in a sessions case, can the court immediately post the case for trial? Charge frame ചെയ്തു അന്ന് തന്നെ വായിച്ചു കേൾപ്പിച്ചു, claims to be tried, then judge calendar നോക്കി date issues summons such and such days. Can it be done now? Or something else has to be done before that? Something else to be done? And settlement.
അതല്ല വക്കീൽ അദ്ദേഹം ചാർജ് ഫ്രെയിം ചെയ്താൽ നെക്സ്റ്റ് അക്യൂസ്ഡിനെ എക്സാമിൻ ചെയ്യാനായിട്ടാണോ കോടതി പോസ്റ്റ് ചെയ്യുന്നത്? ആൻഡ് ആഫ്റ്റർ ഫ്രെയിമിംഗ് ദ ചാർജ് കോർട്ട് വിൽ സ്ട്രേറ്റ് അവേ ഷെഡ്യൂൾ ഇറ്റ് ഫോർ ട്രയൽ. അങ്ങനെയാണോ നിങ്ങൾ എല്ലാവരും പ്രാക്ടീസ് ചെയ്യുന്ന സെന്ററിൽ നടക്കുന്നത്?
അല്ല, ഇപ്പൊ പണ്ടങ്ങനെ
നിങ്ങളും അങ്ങനെയാണോ ധരിച്ചു? ഇറ്റ്സ് യുവർ പ്രൈമർലി ഇറ്റ്സ് യുവർ ഡ്യൂട്ടി ടു എൻലൈറ്റൻ ദം. നിങ്ങൾ എല്ലാവരും സെഷൻ കോടതികളിൽ ഹാജരാകുന്നവരുമാണ് എന്നാണ് എന്റെ വിചാരം.
See, there is a amendment to the Criminal Rules of Practice Kerala, Rule 77, capital letter A, sub rule 2. Rule 77, capital letter A, sub rule 2. അപ്പോൾ ജഡ്ജിന് പണ്ടത്തെ പോലെ കലണ്ടർ നോക്കി ഓർമ്മ സോ ഇഷ്യൂ സമൻസ് അടുത്ത ഡേറ്റിൽ സമൻ ദാറ്റ് കനോട്ട് ബി ഡൺ. പിന്നെ എന്ത് ചെയ്യണം? പബ്ലിക് പ്രോസിക്യൂട്ടറെയും അക്യൂസിൻ്റെ ലോയറേക്ക് വിളിച്ചിട്ട് ഡേറ്റൊക്കെ തീരുമാനിക്കാം. എന്നിട്ട് ചോദിക്കണം എന്ത് വേണം, സൗകര്യപ്പെടുമോ?
ആണോ? 2021 സുപ്രീം കോടതി പറഞ്ഞതാണ്. 2000 ILR
ഞാൻ പറഞ്ഞ പോലെയല്ല, ഞാനത് ഒരു in a humorous sense. This is something serious to be followed.
അല്ല, അതിന് ഒരു ഇതുണ്ട്. അത് അതിനൊരു there is a relevance for this hearing also. That is also clarified by the Supreme Court. And I have also experienced in some trials, advocates may come and they will straight away say that the cross-examination of this witness has to be postponed. That different procedure is now controlled.
After framing of charges, the court has to hold a preliminary case management hearing. Preliminary case management hearing. You may refer to 2021 10 SCC 598. 2021 10 SCC 598. In accordance with the directions of the Supreme Court, now the amendment has been introduced in the criminal rules of practice, making it compulsory on the part of the judicial officers. എന്താ ചോദ്യം? എന്താ?
അല്ല, അതില് ഒരു കാര്യം കൂടെ ഉണ്ട്. ഈ സമയത്താണ് നിങ്ങൾ ഈ ആ പഴയ 231 വരുമല്ലോ, ഡിഫറിംഗ് ദ ക്രോസ് എക്സാമിനേഷൻ. നൗ ഇറ്റ് ഈസ് 254. അത് ആവശ്യപ്പെടേണ്ടുന്നത് ഈ സമയത്താണ്, not at that point of time. Subsequently, when a witness comes and when his chief examination completes, you cannot demand the deferral of cross examination.
It has been issued in accordance with these amendments have been made in accordance with the directions of the Supreme Court. And the criminal rules of practice, though issued by the High Court of Kerala, that amendment, it has to be the concurrence of the state government. It is by the state government ultimately, not by the High Court. Though they are framing the rules.
അതിനും അതിപ്പോ ആ ഒരു പോയിന്റിലേക്ക് പറയാൻ സമയമില്ലാത്തതുകൊണ്ടാണ്. അതിന് വേറെ റൂട്ട് ഉണ്ട്. പഴയ 477 ലാസ്റ്റ് സബ് റൂൾ എടുത്ത് വായിച്ചു.
That is whenever the state government can frame rules, the High Court can also frame rules.
That is a different thing.
On a particular matter. Now, you may also refer to a decision of the Kerala High Court, 2023 7 KSC 155.
സാർ മുമ്പേ പറഞ്ഞ കാര്യം ആ ഡിസിഷനിൽ പറഞ്ഞിട്ടുണ്ടോ?
2023 7 KSC 155. See, many of you may know there is a circular issued by the High Court of Kerala that the judicial officers, especially session judges, shall dispose of such and such a number of murder cases a month or during an year. On that ground, so I have got a target. On that ground, a judicial officer cannot deny adjournment. in an appropriate case, that is also important. In a genuine case where the counsel cannot appear.
But you also show the responsibility. Don't tell them blatantly that court is bound to adjourn it.
No. ആൻറ്റിസിപ്പേറ്റ് ചെയ്യാത്ത കാര്യങ്ങൾ എല്ലാ മനുഷ്യർക്കും ഉണ്ടാവാം. പെട്ടെന്ന് അസുഖമായി പോവാം, അല്ലെങ്കിൽ വീട്ടിലൊരു മരണം സംഭവിക്കാം. വി ആർ നോട്ട് അപ്പൺ ദാറ്റ്. നിങ്ങൾ ചിലപ്പോൾ നേരത്തെ ഒരു പ്രോഗ്രാം പ്ലാൻ ചെയ്തിട്ടുണ്ടാവും. ആ സമയത്തായിരിക്കും ചിലപ്പോൾ സെഷൻസ് കോടതിയിൽ ഷെഡ്യൂൾ വരുന്നത്. യു ക്യാൻ സേ ഇറ്റ് മേ നോട്ട് ബി കൺവീനിയൻറ്റ് ഫോർ മീ such and such time. The other is only adjournment for a short period. I am not commenting upon that. If the director wants to comment, I am not commenting upon it.
I don't want to land into any controversy. Because, see, I have a special trust on my officers of the street. That I believe that unless there are specific grounds, they may not do that. But I am not saying that what you are saying is incorrect. But you must understand the position of a judicial officer also. They are bound by several directions.
That is not correct.
സാറിനൊരു 33 കൊല്ലത്തെ എക്സ്പീരിയൻസ് ഉണ്ട് ആസ് എ ജുഡീഷ്യൽ ഓഫീസർ.
That is only in the trial court. അല്ല, എൻ്റെ എക്സ്പീരിയൻസിന്റെ കാര്യം പറഞ്ഞ
Agiladeva, let's if you got any grievance, you personally come, I will address it. Let's proceed with the discussion. But your grievance is taken note of.
It cannot be totally ignored because a few days back there is a decision by the Kerala High Court in which heavy cost was imposed and it was drastically cut down by the High Court of Kerala. Cost was imposed even then, but it was cut down. Reduced. It was reduced.
My request to you is that don't consider the judges as your enemies. They are also people from your side.
I have conducted many trials. Many trials. Even I have conducted a sensational case trial in which lawyers from different parts of the state appeared, eminent lawyers appearing before the High Court also. I had no occasion to quarrel with them and on issue of an adjournment. That is something a judicial officer, a case management has to be planned, but provided the opposite party, that counsel also should accommodate the judicial officer. Only the bar and bench go together. The trial can be conducted smoothly. And during the examination of these about 167 witnesses, in such a trial, I had no occasion to quarrel with anybody on the issue of adjournment. On the issue of adjournment. And I think nobody had a grievance. No lawyer had a grievance that I did not get sufficient opportunity before me in that particular case. You can endure. That is something to be learned by any judicial officer, but provided the lawyers were also like that. They cooperated with me. Then I suggested some alternative. They will readily agree. That cooperative attitude should be on the part of the lawyers also. Then only it will go smoothly.
In short, nobody.
Like if the judge and the counsel for the accused behave like bitter enemies in the court, nothing could be done. On every point, every stage, it would there be happening.
Let us keep it there. Let's proceed with the discussion.
Now, section 254, the proviso. Section 254 of the BNS deals with examination of prosecution witnesses. The proviso says evidence of a witness under this subsection may be recorded by audio, video, electronic means. So, prosecution witnesses can be examined through audio, video, electronic means in a sessions trial. Now, see whether such a provision is there at the defense stage. Section 256. Section 256. BNS. There is no such provision. So, defense witnesses in a sessions trial cannot be given that facility. Only the prosecution witnesses. I have no practical experience with regard to that, but there is some rule in our state. And that, what is that name? Electronic Video Linkage Rules 2020, I think. 21. And the practice I have heard is that I have no practical experience with that. When I was a trial judge, these things were not there. After recording this will be sent by post.
Email, or they can take a printout, or we will give a scanned copy. They can take a printout, or we will email it to them. They can take a printout, put their signature, send it back to the court. Read out ചെയ്തിട്ട് വാങ്ങല്ലോ കൊടുക്കുന്നത്.
That should be read out at the time of examination. Read out. So, if at all any objection is there, that should be raised at that time. Not only that, As I stated earlier, this is audio, video, electronic means everything will be recorded. You cannot dispute a letter that ഞാൻ പറഞ്ഞത് അതല്ല എന്ന് പറയാൻ പറ്റില്ല ഒരാൾക്കും. ആ റെക്കോർഡഡ് ആയതുകൊണ്ട് തന്നെയാണ് പ്രശ്നം. അത് പിന്നെ ഡിസ്പ്യൂട്ട് ചെയ്യാൻ പറ്റില്ല, ഞാൻ അങ്ങനെയല്ല പറഞ്ഞതെന്ന്.
അതിന് കുറെ കൂടെ സേഫ്റ്റി ഉണ്ട് മറ്റേ മോഡിനേക്കാൾ. ഇതിൽ ഇത് വളരെ ക്ലിയർ ആയിട്ട് റൂൾ 8ന്റെ റൂൾ 16 പറയുന്നുണ്ട്, ദ കോർട്ട് ഷാൽ ഒബ്റ്റെയിൻ ദ സിഗ്നേച്ചർ ഓഫ് പേഴ്സൺ ബീയിങ് എക്സാമിൻഡ് on the transcript once examination is concluded. The signed transcript shall form part of the record of the judicial proceeding. The signature of person being examined shall be obtained in either of the following ways എന്ന് പറഞ്ഞിട്ടാണ് ഈ ഓരോന്ന് പറയുന്നത്. അതായത് ഒന്ന് ഡീറ്റെയിൽ സിഗ്നേച്ചർ ഉള്ള കാര്യം, രണ്ട് ഡീറ്റെയിൽ സിഗ്നേച്ചർ ഇല്ല എങ്കിൽ if not available, the printout of the transcript shall be signed by the presiding officer and the representative of the parties if any at the court point, and thereafter it shall be sent in non-editable scanned format to the remote point through the official electronic mail, where a printout of the same will be taken and signed by the person examined and countersigned by the coordinator at remote point. Done. Rule 8, sub-rule 16. Linkage, electronic video linkage rules for courts Kerala 2021. Sub-rule 16. കോടതി അങ്ങനെ ചെയ്താൽ തർക്കിക്കാൻ ചെയ്യരുത്. ഇറ്റ്സ് ഗവേൺഡ് ബൈ റൂൾസ്. Electronic video linkage rules of Kerala 2021. Electronic video linkage rules for courts Kerala. And now there is a proposal to integrate these rules with the rules of practice also. Yes.
Now, I forgot to state one thing. See, when a prosecution witness is examined, the accuser can, by virtue of section 254 subsection 3, ask for deferring the cross-examination until suppose there are 3 eyewitnesses in a sessions case. When one eyewitness is examined in chief, the defense counsel may ask cross-examination should be deferred till the completion of examination in chief of the other 2 eyewitnesses. Otherwise, I will be prejudiced, because any lacuna brought out through the cross-examination of the first eyewitness will be, the prosecution will try to fill up that lacuna through the examination of the second eyewitness. But that may not always be a correct proposition. That is why the Supreme Court said in AR 2019 Supreme Court 721, that is also a case from Kerala. AR 2019 Supreme Court 721, that this deferral cannot be given as a matter of right. The court should be thoroughly satisfied that this will cause a prejudice. Only then this deferral can be allowed. Deferring of the cross-examination can be allowed. Supreme Court says, because suppose that such an improvement is made by the second witness, that you can point out, that will be against his previous statement. So you can take advantage of defense. Oh, there are many things with regard to examination of witnesses, but that are not with regard to the changes. So I am not going to deal with them. Now, can a general diary be summoned by the defense at the defense evidence stage? General diary. Please first keep it in mind there is a difference between general diary and case diary. I am open general diary. Whether general diary can be summoned or extracts. Recently, our High Court has held that general diary can be summoned at the defense evidence stage. 2024 KER 46996. 2024 KER 46996. Even earlier, there is a decision by the Supreme Court to that effect. AER 1998 Supreme Court 201. AER 1998 Supreme Court 201. Now we come to section 258 of the BNSS. Section 258(1) says, after hearing arguments and points of law, if any, the judge shall give a judgment in the case as soon as possible. As soon as possible. Then, within a period of 30 days from the date of completion of arguments. Which may be extended to a period of 45 days for reasons to be recorded in writing. So 45 days time is granted. And in my view, this is more than enough. Why should there be a 45 days time for a judge to pronounce a judgment? Maybe in very rare cases, where there are hundreds and hundreds of witnesses, it may be required because the judge has to marshal, assess the evidence. Normal cases, it is not sufficient, it is more than sufficient. And the circular issued by the High Court of Kerala states that the judgment shall be pronounced by the session judge within 7 days after completing the arguments. ആ ഇത് വെക്കാം അങ്ങനെ പല സൂത്രപ്പണിയുണ്ട്. See, regarding further hearing, there are two things. One, there may be genuine reasons for having a further hearing. The second thing is to get a time for preparing the judgment. Genuine reasons, I may say, suppose after hearing, a judge hears the thing, then he studies the matter. Then he may entertain some doubts, and he may have his own ideas about that position. In my view, it will always be better to again hear the counsel on those points only. For that purpose, sometimes it may be necessary to post the case for further hearing. I used to do so. And so genuine, for genuine reasons, it may, further hearing may be required sometimes. No. Now, trial of warrant cases by the magistrates. Section 262, subsection 1. That is a new provision. 262(1). The accused may prefer an application for discharge within a period of 60 days from the date of supply of copies of documents under section 230. Here there is no problem because accused appears before the magistrate on summons or when he is produced before the magistrate if he is in custody, then copies of records are furnished to him. Then only from that date this is 60 days is provided here. So there may not be any problem. Now, see, change ഉള്ളതല്ല പറയുന്നത്, എന്നാലും general interest. See, the expression used is when a magistrate can discharge, when as per section 262(2). Corresponding provision section 239 of the code. When the charge is groundless. What does the expression groundless mean? Groundless. No base, no ground. The word groundless means that there must be no ground for presuming that the accused has committed the offense. The word groundless used in section 239 of the CRPC means that the materials placed before the court do not make out or are not sufficient to make out a prima facie case against the accused. That is what the Supreme Court says, groundless. You may refer to AIR 2022 Supreme Court 4218. AIR 2022 Supreme Court 4218. It is, if I remember correctly, it is a case under the BCA. So when you see, this is BCA, we are not in that field. So ignore. Don't do that. As far as possible, the criminal lawyers going to, whichever field they practice, try to read all judgments on whatever be the branch, whatever be the statute, whether it is BNS Act or BNS Act, there will be something there in that judgment of general importance. For example, recently the Supreme Court held in that in the case of Prabir, Paraga is See, it is I think under the PML. There is one important thing mentioned by the Supreme Court in that there is a provision in the CRPC and in the Constitution also that when a person is being arrested, grounds of belief should be there. Grounds of belief or see. Uh, Section 50 code. Grounds and the expression of the grounds of arrest. Grounds of arrest shall be communicated to the accused. That is in the Constitution also, but nowhere it is stated that it should be in writing. And the Supreme Court held that in UAPA as well as that is a case under the UAPA. UAPA as well as the PMLA cases, these grounds of arrest should be communicated in writing. Shall be in writing. In writing nowhere stated. But while holdings of the Supreme Court has also stated that that is applicable to other offences also. That is applicable to other offences also. But if you want to know about it, you shall carefully read that paragraph. Then only you will be able to understand. That is why I stated do not ignore any of the judgments. Then section 263(1). See, the main provision 263(1) is the same as in the code, but with a rider. The framing of charge shall be done by the magistrate within a period of 60 days from the date of first hearing on charge. That is added there. Within a period of 60 days from the date of first hearing on charge. Why there should be a period of 60 days? There is no necessity for such a long time for framing charge. See, there the expression used is first hearing. And this has got some significance with regard to what you said earlier regarding this further hearing. Because the expression used is from the date of first hearing. Charge frame cheyanam first hearing on framing charge. എന്താ ആ എന്താ അതിന് പ്രശ്നം? എന്താ കോംപ്ലിക്കേഷൻ? Within a period of 60 days from the date of first hearing on charge. Suppose, as I stated earlier, further hearing എന്ന് പറഞ്ഞിട്ട് കാര്യമില്ല. From the first day when the matter is taken up for hearing by the court and the matter is heard, at least in party. In some cases, in complicated cases, it may go on for days, not in the ordinary cases. എന്താ ഇതിന് കോംപ്ലിക്കേഷൻ? അതിനകത്ത് സെക്ഷനിൽ ഒരു കോംപ്ലിക്കേഷനും ഇല്ല. ഒരു വേഗ്നസും ഇല്ല. Then the second proviso to section 265(3). See, that is a prosecution evidence. As in the case of sessions trial, here also, second proviso states the examination of a witness under this subsection may be done by audio, video, electronic means, but here there is a rider. At the designated place to be notified by the state government. That should be done. That condition is not there when the witness is examined in a sessions trial case. Then, the second proviso to section 266. That is the defense evidence. Second proviso. Same thing, provided further that the examination of a witness under this subsection may be done by audio, video, electronic means at the designated place. So, this enables, before a magistrate during a trial of warrant case, defense evidence can be, or a defense witness can be examined through audio, video, electronic means, but not provided in the case of a sessions trial. Now, see, in private complaint cases, warrant trial, you know the procedure. Before framing of the charge, the complainant and his witnesses will be examined. Whether the accuser has got a right to cross-examine the witnesses of the complainant at that time, pre-charge. Whether the accuser has got a right to cross-examine, the answer is yes. The answer is yes. He has got a right. But he may, at his option, defer the cross-examination to a later stage after the charge. Now, suppose the witnesses examined by the complainant at that time, their presence could not be secured after framing of charge. when evidence is being taken. You may now go to the provision section 269 subsection 7. 269 subsection 7. Where despite giving opportunity to the prosecution and undertaking all reasonable measures under the Sanhita, if the attendance of the prosecution witnesses under subsections 5 and 6 cannot be secured for cross-examination, all reasonable steps should be taken to secure their presence. In spite of such steps, their presence cannot be secured. Then it shall be deemed that such witness has not been examined for not being available, and the magistrate may close the prosecution evidence. Magistrate may close the prosecution evidence for reasons to be recorded in writing and proceed with the case on the basis of the materials on record. Proceed with the case on the basis of the materials on record. Here I have got a doubt. It is for you to clear my doubt. The expression used is proceed with the case on the basis of the materials on record. My doubt is whether these materials on record, that expression, will include the examination in chief of the complainant's witnesses, such witnesses before charge. The accused had the right, the opportunity to cross-examine. What about the section 33 of the Evidence Act? You may work out this question. Keep it in mind. Section 33 of the Evidence Act, corresponding provision is there in the BSA. Now, section 272. Suppose under the code, section 249, if the offence is compoundable and if the offence is also non-cognizable, and if on a particular date the complainant is absent, the court had the power to discharge the accused if it was a stage before framing of charge. Section 249. Corresponding provision is section 272. 272. Here also the court can discharge in such a situation, provided one thing is added: after giving 30 days time to the complainant to be present. So the court cannot immediately discharge the accused, but grant 30 days time to the complainant to be present. Now, trial of summons cases by magistrates. Section 274 of the BNSS. Corresponding provision is Section 251 of the Code. There is no change in the main provision, but a proviso is added there. That is a new provision, provided that if the magistrate considers the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such a release shall have the effect of discharge. So, as you know, under the code, there is no provision for discharge in a summons case. And it is also not necessary in a summons case under the code to frame charge here also. But if the magistrate considers that the accusation against the person accused is groundless, there also the word used is groundless. We can import the same meaning from Section 239 as stated earlier. Then, he shall, after recording reasons in writing, not discharge the accused, but what? What is the order to be passed? Release the accused, which shall have the effect of discharge. That is deemed discharge. Deemed discharge. There is some history behind this provision. On account of paucity of time, I am skipping. Now, Section 256 of 1 of the code, when in a summons case, if it is on a complaint, when the complaint is absent, the accused may be acquitted by the accused, the magistrate. Section 256(1) of the code. Corresponding provision is Section 279(1). 279(1). There also the same thing is provided, but with a condition, as in the other case, as in the other provision, after giving 30 days time to the complainant to be present. So immediately the accused cannot be acquitted, stating that the complainant is absent. Even otherwise, under the code also, there are ever so many rulings which say that if the complainant is absent on a particular day, the court has to consider whether his absence has in any manner affected the progress of the trial of the case. Only if his absence affects the progress of the trial of the case, the accused can be acquitted. Suppose his presence is not necessary on that day for the progress of the trial of the case, the accused cannot be acquitted. There are ever so many rulings. Now, I will ask you a question. In connection with this. Suppose in a 138, section 138 of the NI Act case, the evidence of the complainant is over. The accused was examined under section 313 CRPC. Now the corresponding provision is there. Thereafter, the case was posted for defense evidence, and on that day, defense witnesses are present, but the complainant is absent, his counsel is also absent. Can the court acquit the accused on the ground that the complainant is absent? Why? And ഇത്തിരി ഉറക്കെ പറഞ്ഞു കംപ്ലൈന്റ്
The progress of the case, presence of the complaint is as delayed. Defense evidence വരുന്നത് ക്ലയന്റിന്റെ അതിന്റെ എവിഡൻസിന്റെ ഭാഗം.
The Supreme Court has stated that the accused cannot be acquitted because if the complainant and counsel is absent, no problem. There is no cross-examination of the defense witnesses. That is the only effect. So the court has to proceed on the basis of the materials on record, already the evidence already adduced, and dispose of the case on merits. 2023 for SCC 326. 2023 for SCC 326. Now, summary trials. The provision under the code is section 260. The corresponding provision in the BNSS is section 283. Regarding the offences which can be tried summarily, there are changes. I am not going to explain them. You may read and understand what are the changes regarding the offences mentioned, which can be tried summarily. But the important change is not that. The important change is this. The provision starts section 283(1). Notwithstanding anything contained in the Sanhita, not absentee clause. Any CJM, magistrate of the first class, shall try in a summary way all or any of the following offences. Shall try. Earlier in the code under section 260, it is may. The court may try. Now it becomes shall. Now plea bargaining. Section 265 capital letter A of the code is a provision under the code. Corresponding provision is section 289 of the BNSS. There are slight changes here and there in that chapter, in the provisions in that chapter. But I will emphasize one thing. Regarding certain offences, in case of certain offences, plea bargaining cannot be done. That is provided under section 289 1 B കഴിഞ്ഞിട്ട് but does not apply where such offense affects the socio-economic condition of the country. That was earlier under the court. That was that there. Then, or has been committed against a woman. That is also there. Then, or a child. Earlier, under the code, the expression used was not child, but a child below the age of 14 years. Under the code, now it has become a child, that means 18 years. That is the main difference. Now, section 316. Subsection 4. Subsection 4. That is a new provision. Provided that where the accused is in custody and is examined through electronic communication, his signature shall be taken within 72 hours of such examination. This is the provision which I earlier stated. If he is in custody, that is a provision. But see, the way the expression used is not 3 days, not 3 days, but 72 hours. 72 hours. Now we come to now see the code contains a provision which allowed admitting in evidence the report of experts without examining them, without formal proof. That is section 293. The corresponding provision is section 329. Subsection 4 അതിൽ ക്ലോസ് G എടുക്കുക. ക്ലോസ് G. Sir, it states that these government experts A, B, C, D, etc. പറഞ്ഞിട്ടുണ്ട്. അവരുടെ റിപ്പോർട്ട് ആകുമ്പോൾ there is no formal proof necessary. Then G, any other scientific expert. There, under the code, it was any other government scientific expert. So the government is omitted. What will be the effect? Private expert can be notified by the government, and if not so notified, the provision will apply. Without the formal proof, the report can be admitted in evidence. Now, recently the Supreme Court had occasion to consider the value of a report obtained from a private laboratory, not notified by the government, but private laboratory. And what the Supreme Court stated is this: a paid report obtained from a private laboratory seems to be a fraud, unreliable, unsafe, untrustworthy, and imprudent form of evidence unless supported by some other corroborative proof. AIR 2024, Supreme Court 801. AIR 2024, Supreme Court 801. Now, you may take section 329, subsection 4, another A, B, C, D, E. പറഞ്ഞിട്ടുണ്ട് അതിൽ ക്ലോസ് എ എടുക്കുക. ക്ലോസ് എ, സി any chemical examiner or assistant chemical examiner to government അവരുടെ റിപ്പോർട്ടാണെന്നുണ്ടെങ്കിൽ no formal proof necessary. My question is, suppose the report is issued by a joint chemical examiner. That's not provided there. Whether it can be admitted in evidence without a formal proof. If it is a joint report issued by a government joint chemical examiner. ആകാമോ അല്ലയോ, പറ്റുമോ ഇല്ലയോ? That is any chemical examiner. Any chemical examiner includes a joint chemical examiner also. You may refer to 1985 KLT 33. 1985 KLT 33. Then 1988 2 KLT 848. 1988 2 KLT 848. Now take ഇപ്പൊ എ ആണ് വായിച്ചതല്ലേ, ക്ലോസ് ഇ എടുക്കാം. ഇ, the director, deputy director or assistant director of a central FSL or state FSL. അവിടെ any director എന്നില്ല. The director, the director, deputy director or assistant director of a central FSL. Here again, my question is, if the report is issued by a joint director of the FSL, whether it is admissible in evidence without formal proof.
അവിടെ ഇനിയില്ല.
ഇനിയില്ല. നേരത്തെ ഇനി പറഞ്ഞിട്ടാണ് നമ്മൾ അല്ലേ, ഇനി ഇവിടെ ഇനിയില്ല. പറ്റുമോ ഇല്ലയോ?
What is the logic? Etymologically equivalent to director.
A director includes a joint director. That is what the Supreme Court said. A director includes a joint director. AIR 1998 Supreme Court 260. AIR 1998 Supreme Court 260. അതിന്റെ പാരന്റ് കേസ് കേരളത്തിൽ നിന്നുള്ളതാണ്. കുറച്ച് പ്രാക്ടീസുള്ള ലോയേഴ്സിന് ചിലപ്പോൾ ഓർമ്മയുണ്ടാവും. സ്റ്റേറ്റ് ഓഫ് കേരള വേഴ്സസ് അമ്മിണി 1987 1 KLD 928. 1987 1 KLT 928. That was affirmed by the Supreme Court in AIR 1998 Supreme Court 260. Now, this position was recently reiterated by the Supreme Court in 2024 KSC Online 6147. That is also a case from Kerala. 2024 KSC Online 6147 Supreme Court. Now, suppose there is a provision in the IT Act, Section 79, capital letter A. When digital evidence is collected and analyzed, it shall be done by only by a notified agency. That notified agency, as well as our state is concerned, is the cyber division of the FSL Trivandrum. Here again, I have got a question. A digital evidence is now analyzed and a report is issued by a government expert, but not by an expert from the cyber division of the FSL Trivandrum. Can it be admitted in evidence under the old section 293 CRPC without formal proof or corresponding provision section 329?
But a special act stipulates a procedure of notification, and in defense of the same can be invoked section 293 or 329 of the present Sankida. 79 will prevail.
79 capital letter A. Then our High Court has held that it is admissible in evidence under section 293 CRPC. You may read 2024 KSC Online 410. 2024 KSC Online 410. The same view has been taken by the Allahabad High Court in the year 2022 in a decision. You will get that decision in Manu Patra. Manu /UP /4638 /2022 2022. Manu /UP /4638 /2022.
Let's break for tea. Come after 15 minutes.
Now we will welcome back. Now we will go a bit faster so that it can be completed before lunch. Now section 330 of the BNSS, it is corresponding to section 294 of the CRPC. As you know, under section 294 CRPC, the procedure is that if suppose a document is filed with a memo and if it is given to the opposite side, and if they can be asked to deny or admit it, and if they admit it, it can be admitted in evidence without any formal proof. The same procedure is here, but a rider is under the last portion of section 331. That can be done in no case later than 30 days after supply of such documents. Then comes the proviso, the court may in its discretion relax the time limit for reasons to be recorded in writing. The next proviso is important, second proviso, provided further that no expert shall be called to appear before the court unless the report of such expert is disputed. So, unless it is disputed, expert shall not be called to appear before the court. Now, if you want to know more about the procedure under section 294 CRPC, then you may refer to 2016 15 SEC 485. 2016 15 SEC 485. Again, 2023 7 KSC 512. 2023 7 KSC 512. Now, recently, on 12/7/2024, the Supreme Court has held this. This was held by the Supreme Court. I will read. Calling upon the accused to admit or deny the genuineness of the documents produced by the prosecution along with the list under section 294 CRPC could not be said to be in any way prejudicial to the right of the accused. It will not cause any prejudice to the accused. Nor could it be said to be compelling him to be a witness against himself, as contemplated under Article 20, Clause 3 of the Constitution of India. That is, if anybody has a subscribe to live now, you will get it. 2024 live law Supreme Court 480. 2024 live law Supreme Court 480. Now, see, suppose nowadays, suppose a doctor is who has issued the postmortem certificate or a wound certificate is bedridden, not able to appear before the court, or if he is abroad, or if he is dead. What is the procedure adopted nowadays? Any person, any other doctor who is acquainted with the signature and handwriting of that doctor who issued the postmortem certificate or the wound certificate would be examined and it would be proved. What is the evidentiary value? That is something different. Anyway, proof is like that. Now that procedure has been approved by the Supreme Court. Now, the relevant provision is section 32 of the Evidence Act. Now, Supreme Court has approved that practice in AIR 1989, Supreme Court 702. AIR 1989, Supreme Court 702. I will give you a Kerala ruling also, very important. 1979 KLT 550. 1979 KLT 550. Now we come to, having stated so, I will come to section 336 of the BNSS. Now under the BNSS, these difficulties are not there. If any public servant, not merely an expert, if any public servant, his presence could not be secured, then any person, the person who is sitting in that chair at the time of examination of the witness can be summoned and examined, and this document can be proved. ആ കസേരയിലിരിക്കുന്ന ആളെന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ ഡോക്ടർ ഇരിക്കുന്ന കസേരയിൽ ഇപ്പൊ നഴ്സ് കയറിയിരുന്നു കഴിഞ്ഞാൽ കഴിയില്ല. I mean successor in office. Successor in office. Successor in office at what time? At the time of examination. That is important. So this is applicable to public servants, experts, police officers, etc. And you may read the provisions. There is no need of explaining all this. See, it is provided there when the public servant has retired or transferred. Even transferred. That is there. Now, section 341, subsection 1. 341, subsection 1. Legal aid. Where in a trial earlier under the code, it was provided where in a trial before the court of session. Now it is where in a trial. So, whichever be the court. Or appeal before a court. That is added. Appeal before a court. The accuser is not represented by an advocate. Same provision then. Same provision as in 304 subsection 1 of the code. Now, there are slight changes regarding some other sections. I am skipping them. Then adjournments. Corresponding provision of the code is section 309. The provision under the BNS is section 346. 346. 346 subsection 2 clause B. Another adjournment. Adjournment എപ്പോഴൊക്കെയാണ് ചോദിക്കാൻ പറ്റുക? Subsection 346. Third provision. Clause B of the third provision. Clause B of the third provision. Sorry. Eh? 346. Yes, fourth proviso. Sorry. Clause B. Adjournment. Where the circumstances are beyond the control of a party, not more than 2 adjournments may be granted by the court after hearing the objections of the other party and for reasons to be recorded in writing. Suppose it is a third time beyond the control. Beyond the control of a party, third time. അതായത് ആദ്യത്തെ ഒരു തവണയോ അല്ലെങ്കിൽ രണ്ടാമത്തെ തവണയോ ഇപ്പൊ കൗൺസിലിന്റെ ആണെങ്കിൽ മാത്രമേ പറയാൻ പറ്റുള്ളൂ. അത് ഞാൻ പറയാൻ പോണത് ആ കൗൺസിലിനെ കൊണ്ട് പറ്റിയില്ല എന്ന് വെച്ച് കഴിഞ്ഞാൽ ഇനിയിപ്പോ മൂന്നാമത് ഈള് വരണ്ട, വേറെ കൗൺസിലിനെ ഏർപ്പാട് ചെയ്തോളാം. Now, section 349 corresponding provision is section 311 capital letter A of the code. See, can a magistrate direct an accused to provide voice sample to the investigating officer? Under the code, what is the provision? Which is the provision? Huh? No provision. Then, where does the magistrate get that power? From where? The Supreme Court in Research the Singh's case, that is AR 2019 Supreme Court 3592, AR 2019 Supreme Court 3592, held that till the statute intervenes, till the legislature intervenes and makes some provision, the magistrates are empowered to direct any person to provide the sample. Now, Supreme Court has directed, held so it is incorporated now under section 349 voice sample. One more thing is also added there, that is finger impression. Finger impression. That is the only change. Then there is also a slight change. See, in order that this provision to be applicable, the person to be directed shall be arrested. That is under the code also. At some stage of the proceedings. Now, the proviso says that the magistrate can, for reasons to be recorded in writing, say that no, there is no need of arrest. So, even if a person is not arrested during the proceedings, he can be directed. '79 capital letter A of the IT Act. For that, you may read the decision in 2022 7 KSC 240. 2022 7 KSC 240. Now, Section 356. Trial in the absence of the proclaimed offender. Yesterday, when I referred to section 84(4) of the BNSS, I stated that this expression proclaimed offender has got some significance. This is the significance. Trial can be held in the absence of not any accused, but a proclaimed offender. 356, the procedure is provided. Not merely a proclaimed offender, but see section 356(1), notwithstanding anything contained in this Samhita. It is a non-obstantly clause or in any other law for the time being in force. When a person declared as a proclaimed offender, whether or not charged jointly, has absconded to evade trial, and there is no immediate prospect of arresting him. These preconditions have to be satisfied. First, he should be a proclaimed offender. He should have absconded to evade trial. Suppose a person is employed abroad. When he is absent, the court has declared him as a proclaimed offender. Whether it will apply? In my view, it cannot, because he has not absconded with a view to evade trial. Then there is no immediate prospect of arresting him. That should be also be there. Then he can be tried in his absence, proceed with the trial as if he is present. That is what is said. And pronounce the judgment. പിന്നെ ബാക്കി അതിൻ്റെ ഡീറ്റെയിൽസ് ഒക്കെ പറയുന്നുണ്ട്. യു ക്യാൻ റീഡ് ആൻഡ് അണ്ടർസ്റ്റാൻഡ്. ആ എപ്പോൾ അപ്പീൽ പോകാം, അല്ലെങ്കിൽ ആ എവിഡൻസ് എന്താണ് എൻ്റെ വാല്യൂ, വാട്ട് ആർ ദി അതർ പ്രീറിക്വിസിറ്റ്സ്, പബ്ലിക്കേഷൻ ഇൻ ന്യൂസ് പേപ്പർ ഒക്കെ പറയുന്നുണ്ട്. ഓൾ ദർ തിങ്സ് ആർ പ്രൊവൈഡ്. പിന്നെന്താ വെച്ചാൽ 90 days കഴിഞ്ഞ് ചാർജ് ഫ്രെയിം ചെയ്ത് 90 days കഴിഞ്ഞിട്ട് ട്രയൽ തുടങ്ങാമെന്ന് പറയുന്നുണ്ട്. അപ്പോൾ ചോദിക്കും എങ്ങനെയാണ് അക്യൂസഡ് ഇല്ലാണ്ട് ചാർജ് ഫ്രെയിം ചെയ്യണം എങ്ങനെയാണ്? അപ്പോൾ സിംഗിൾ ഒരു അക്യൂസഡേ ഉള്ളൂ ഈ ഒരു കേസിൽ. That is why, notwithstanding anything contained in the Samhita or in any other law, then that is also provided. The provision also says that at the cost of the state, he shall be provided a counsel. From where he will get instructions? I don't know. അത് കഴിഞ്ഞാൽ അങ്ങനെ പറഞ്ഞിട്ട് കാര്യമില്ല. 3 years കഴിഞ്ഞ് ജഡ്ജ്മെന്റ് ഓഫ് കൺവിക്ഷൻ വന്ന് 3 years കഴിഞ്ഞാൽ അപ്പീൽ നിൽക്കില്ല. അത് തന്നെയല്ല, നോ അപ്പീൽ ഷാൽ ലൈ അഗൻസ്റ്റ് ദി ജഡ്ജ്മെന്റ് അണ്ടർ ദി സെക്ഷൻ unless the proclaimed offender presents himself before the court of appeal. That is also there. Now, this provision has been incorporated by the legislature in view of the suggestion made by the Supreme Court in one decision. That is, AR 2017 Supreme Court 1362. AR 2017 Supreme Court 1362. Now the next important provision is, see, under the code, which is the provision for withdrawal from prosecution, section 321, the corresponding provision is section 360. There are two changes. One is important. One change is with regard to the investigation, which agency investigated. That is not important. The important change is with regard to this, the proviso to section 360 provided further that a section no court shall allow such withdrawal without giving an opportunity of being heard to the victim in the case. Even otherwise, the courts used to hear the victim nowadays. Eh? Victim വേണമെങ്കിൽ അത്രേ ഉള്ളൂ. മരിച്ച ഒരാൾക്ക് ഓപ്പർച്യൂണിറ്റി കൊടുക്കണം എന്നല്ലല്ലോ എഴുതിയിരിക്കണേ. ആ അതുകൊണ്ടെന്താ? Now, see, when otherwise Supreme Court has stated in the year 2022 that a victim has got participatory rights at every stage of the proceedings. From which stage? From which stage? From the very date on which the occurrence took place till the matter ends in appeal or revision. And that is not mere participatory rights, but the Supreme Court uses the word the victim has got unbridled participatory rights. AR 2022 Supreme Court 1918. AR 2022 Supreme Court 1918. Suppose withdrawal application is not allowed by the court, whether the accused can challenge that order, whether the accused recently our High Court has held that the accused cannot challenge that order. If at all it is to be challenged by the public prosecutor. 2024 KSC Online 539. 2024 KSC Online 539. Now, section 366, subsection 2, in camera trial. Section 366, subsection 2. There, some offences are mentioned that is with consent to the rape. Now, this is added there under sections 4, 6, 8 or section 10 of the POCSO Act. That is added there. Now, the chapter regarding chapter containing provisions as to accused persons of unsound mind from section 367 of the BNS onwards. Section 367 onwards. There are slight changes here and there. One important change only I will mention. Under the code, the word mental retardation is used. Persons of mental retardation. That is there. Now this mental retardation is omitted and substituted with the word intellectual disability. Intellectual disability. Mental retardation is substituted with the expression intellectual disability. That is the main change. Now, section 392, judgment. Here also it is provided that not later than 45 days. This is the general provision. The other provision applicable to sessions trial cases. There a cap is provided in between as 30 days. In the general provision, that cap is not there. That outer limit is not there in the general provision. Section 392, subsection 1. ഇനി അതിന്റെ subsection 4, subsection 4 proviso. See, the direction of our High Court is that if a judgment is pronounced, it shall be uploaded on the same day. Same day. Now the proviso states the court shall, as far as practicable, upload the copy of the judgment on its portal within a period of 7 days from the date of judgment. Now, witness protection scheme, section 398. That is a new provision. 398. That is a new provision. Every state government shall prepare and notify a witness protection scheme for the state with a view to ensure protection of the witness. Here I will say one thing. Recently, the Supreme Court held that, not on this point, suppose in an appeal, when sentence is suspended, the court used to impose a condition that a part of the fine amount or a part of the compensation amount shall be deposited. Now, in one case, the appellate court suspended the sentence on the condition that 50% of the compensation amount shall be deposited. What the Supreme Court said is this: taking into account the purpose and object of section 357 CRPC, the direction of the appellate, that is the direction of the court granting suspension of sentence subject to the condition of depositing 50% of compensation is not justified. Is not justified. Now, in one case, the appellate court suspended the sentence on the condition that a part of the fine amount or a part of the compensation amount shall be deposited. What the Supreme Court said is this: taking into account the purpose and object of section 357 CRPC, the direction of the appellate, that is the direction of the court granting suspension of sentence subject to the condition of depositing 50% of compensation is not justified. Is not justified. 2024 Live Law Supreme Court 478. 2024 Live Law Supreme Court 478. Now section 404. അതിന്റെ subsection 5 എടുക്കുക. അതിൽ second proviso, that is a new provision. Provided further that the court may, on an application made in this behalf by the prosecuting officer, provide to the government free of cost a certified copy of the judgment, order, deposition or record. So any record. No. Now with regard to appeals, there is no substantial or material changes there, except that the provision for appeal from a sentence of from a conviction of an assistant session judge, that is omitted, because there will not be any assistant session judge. Then there are slight changes, not of any impact. Not having any impact. Then പെൻഡിങ് മാറ്റേഴ്സ് വീണ്ടും 531 പോകൂ. അപ്പീൽ പറയുന്നില്ലേ അതിനകത്ത്? അപ്പീൽ പെൻഡിങ്, അപ്പീൽ സ്പെസിഫിക് ആയിട്ട് പറയുന്നില്ലേ? Not only that, with regard to appeal, suppose there is no change with regard to the procedure. Maybe the form may be different in view of this. Because under the code, if I remember correctly, if the sentence is below 7 years or below, the appeal will lie to the sessions court, I think. Now that may go, maybe. But the accused has no vested right in any forum or in procedure. A 7-judge bench of the Supreme Court had, as early as in 1950s held. The accused has no vested right in a forum or in a procedure, unless it violates some constitutional provisions. Now, section 472. That is a new provision. You may read with deals with the mercy petitions. Mercy petitions. The procedure. Then section 474 of the BNSS, commutation of sentence. There are drastic changes. But I am not explaining, because we are not usually concerned with all these things. It is the power of the government. Section 474. Then what is the provision relating to bail in bailable cases under the code, section 436. The corresponding provision is section 478. 478. There is no change with regard to the law in principles or the concept regarding bail and bailable offences. But there are slight changes in the provisions. ബോണ്ട് എന്നുള്ളിടത്ത് ബെയിൽ ബോണ്ട് എന്ന് പല സ്ഥലങ്ങളിലും ഉപയോഗിക്കുന്നുണ്ട്, ആഡ് ചെയ്തിട്ടുണ്ട്. ബോണ്ട് എന്ന് മാത്രം പറഞ്ഞിരുന്ന സ്ഥലങ്ങളുടെ കോഡിൽ, പിന്നെ ബെയിൽ ബോണ്ട് എന്ന് മാത്രം പറഞ്ഞിരുന്നിടത്ത് ബോണ്ട് കൂടി ആഡ് ചെയ്തിട്ടുണ്ട്. കാരണം ഇൻ വ്യൂ ഓഫ് ദി definition we have seen that difference. That is the only change regarding bailable offence. Now, regarding the non-bailable offences, which is the provision under the code 437, the corresponding provision is section 480. There are only two changes. One change we have already discussed, which is that provision. The change we have already discussed under section 480. 187 in relation to 187. Merely for the reason that the police may seek custody of a person, letter will not be a ground to refuse bail. The third proviso to section 480 subsection 1. Now there is a slight change in the first proviso also. In the first proviso, section 480 subsection 1 in there, for certain categories of persons, bail can be granted by the magistrate. There, under the code, instead of the expression child, it was a person aged below 16 years. Now it has child, it becomes child. Under the age of 16 years, that is now substituted with the expression child. Even that is not necessary, because regarding bail in non-bailable cases with regard to a child in conflict with the law, the provision is JJ Act, which provision? Section 12. Now we come back. Section 436, capital letter A. Section 436, capital letter A of the code. See, if a person is continued to be in custody during the inquiry, investigation and trial, and if he completes the custody for a term 1/2 of the imprisonment provided for that particular offence, he shall be released. That is the sum and substance. Now, the corresponding provision is section 479. 479. There are some drastic changes made with regard to that provision. Now, section 436A of the code was not applicable in case of an offence for which the punishment of death was prescribed. If the punishment of death is there for an offence, 436A not applicable. Now, in the corresponding provision 479(1), life imprisonment is also added. So, if an offence is punishable with death or life imprisonment, Section 479 will not be applicable. Then, the first proviso to Section 479(1), first proviso, 479 Suppose a person is first time offender, then this the 1/2 period earlier stated, that has become 1/3. 1/3. Now, Section 479(2), that is a new provision. All things stated in subsection 1 will not be applicable, or it will be subject to the condition that it will not be applicable where an investigation, inquiry, or trial in more than one offence or in multiple cases are pending against a person. So, if there is more than one case against a person and if investigation, inquiry, or trial is pending, this provision will not be applicable. See, there the expression used is not in multiple cases alone, but in more than one offence. That may have some problems because a person may be accused of more than one offence in a single crime case against him. So, investigation may be pending in both. ഓറ് തന്നെയാണ്, അതുകൊണ്ട് തന്നെയാണ് പറഞ്ഞത്, ഓറ് തന്നെയാണ്. That has to be interpreted. Otherwise, that provision will become redundant. In most of the cases, there will be more than one offence. Then, Section 479, subsection 3, that is a new provision. Who shall make an application for bail? It is a duty of the superintendent of the jail to make application. For releasing such a person on bail. But our Supreme Court has held that it is the obligation, duty of the session judges and the magistrates to identify these persons by calling the details from the jails concerned and then go to the jail, conduct sittings there and release them on bail. There is not even an application necessary. Sadendra Kumar Andil, not even an application necessary in such cases. Sadendra Kumar Andil, 2022, for KSC 570. 2022 4 KSC 570 Supreme Court. Then, see, this provision under the code also and under this provision also 479, it is stated that the court may, for reasons to be recorded, refuse to release him on bail. Even if he completes this period. See, provided further that the court may, after hearing the public prosecutor and for reasons to be recorded in writing, order the continued detention of such a person for a period longer than 1 hour. See, the Supreme Court has stated in one case that the provision under section 436 capital letter A is akin to the provision under section 167(2). What does it mean? നൂറ്റി അറുപത്തേഴ് രണ്ടിന് തുല്യമാണെന്ന് പറഞ്ഞാൽ എന്താ അർത്ഥം? It has become his right. The court has no option at all then. That is that PMLA case, Vijay Madanlal Chowdhury, 2022 KSC online 6742. 2022 KSC online 6742. Corresponding provision 2022 SCC online Supreme Court 929. 2022 SCC online Supreme Court 929. Now, one more thing Sarendra Kumar Andil says. This period, though it is stated during the inquiry, trial and investigation, investigation, inquiry and trial, this period is in custody during appeal or revision also, that shall also be reckoned for computing this period. That is Sarendra Kumar Andil. Now, the power of the High Court and the Court of Session to grant bail, that is under the Code section 439. Corresponding provision is section 483. The change is only in the second proviso to section 483(1). There some offences are mentioned. There is a slight change there. Earlier, those offences meant that a rape or gang rape of a woman aged below 16 years. Now it has become, in view of these new offences, 18 years. That is only difference. Now, anticipatory bail, there also now section, the presence of the informant obligatory, that is section 439(1) capital letter A. Corresponding provision section 483(2). There also that applies. Gang rape of a woman below the age of 18 years. That means any girl child. Notice has to be given. Then anticipatory bail, the provision under the code section 438, the corresponding provision section 482. There is no change with regard to the main provisions or in the concept. The change is only with regard to section 482(4), that is corresponding provision section 438(4). No anticipatory bail in certain cases. Rape cases, where earlier it was a gang rape of a woman aged below 16 years, now it has become 18 years. In such cases, no anticipatory bail at all. Bar. There also our High Court has held that before that bar is made applicable, the court has to look into the facts and circumstances of the case and ascertain whether there is a prima facie case, as in the case of SC/ST Act. SC/ST Act section 18 bar ഉണ്ട്, 18A bar ഉണ്ട്, capital letter A. പക്ഷേ സുപ്രീം കോടതി എന്താണ് പറഞ്ഞത്? ആ ഇൻഗ്രീഡിയൻസ് വരുന്നുണ്ടോ എന്ന് നോക്കണം അലിഗേഷൻസിൽ, എങ്കിൽ മാത്രമേ ആ ബാർ അപ്ലൈ ചെയ്യുള്ളൂ. ഹിയർ ആൾസോ ദി സെയിം പ്രിൻസിപ്പിൾ. യു മേ റെഫർ ടു 2023 6 KSC 158. 2023 6 KSC 158. Suppose an application for anticipatory bail is pending before the court of session or the high court. During the pendency of the application for anticipatory bail, whether the investigating officer can arrest the accused. And he can be arrested provided there is no stay or interim bail granted by the stay of arrest or interim bail granted by the court. AR 2024 Supreme Court 1600. AR 2024 Supreme Court 1600. Now, what is the provision under the code regarding entering custody of property? Section 451. Corresponding provision is section 497. (497)(1) says when any property is produced before any criminal court, that is in the code also, then added these things added, or the magistrate empowered to take cognizance or commit the case for trial. That is added. During enquiry or trial, that is in the code, but here 497 under 497(1), investigation is also added. If the property is produced during investigation, enquiry or trial. These changes have been incorporated in the subsequent provisions also whenever necessary. Whenever necessary. Now, subsections 2 to 5 are new provisions. Subsections 2 to 5 of section 497, new provisions. You may read and read it, no problem. This is in more or less in consonance with the spirit of the Supreme Court decision in Sundarbhai Ambalal Desai versus State of Gujarat, AR 2003, Supreme Court 638, AR 2003, Supreme Court 638. Suppose a vehicle is involved in an accident, motor vehicles accident, and it is seized by the police and produced before the court, but that vehicle has got no third party insurance. Can the vehicle be released on normal conditions? Why it cannot be? Rule 391, capital letter A of the Kerala Motor Vehicles Rules 1989. You may also read the decision in 2023 3 KSC 477. 2023 3 KSC 477. Now, What is the provision regarding limitation under the code? Section 468. The corresponding provision is section 514 of the BNS. The main provision is the same, but an explanation is added there that is new. For the purpose of computing the period of limitation, the relevant date shall be the date of filing complaint under section 223 or the date of recording of information under section 173. This is stated also by the Supreme Court in earlier decisions, AIR 2014 Supreme Court 448, AIR 2014 Supreme Court 448, reiterated by the Supreme Court in 2022 13 SCC 128, 2022 13 SCC 128. Is it necessary that before condonation of delay to issue notice to the accused? That is under section enquiry ആണ് കോഗ്നിസൻസ് എടുക്കുന്ന കാര്യത്തിലാണ് അത് കഴിഞ്ഞിട്ടുള്ള കാര്യം എന്ന് പറയുന്നത്. മറ്റേ കോഗ്നിസൻസ് എടുത്ത് കഴിഞ്ഞിട്ടുള്ള കാര്യം എൻക്വയറിയിലുള്ള കാര്യമാണ് പറയുന്നത്. Is it necessary to issue notice to the accused before condonation of the delay? See, when a prosecution is barred by limitation, the accused has got a vested right. That is, when the court condones the delay, that right is taken away. Then that bar is removed. So then it is not necessary to hear him. It is necessary to issue him notice and afford him an opportunity of being heard. AIR 2008 Supreme Court 1937. AIR 2008 Supreme Court 1937. Again, AIR 1995 Supreme Court 231. AIR 1995 Supreme Court 231. Now section 530. That is a new provision. 530. That is a new provision. All trials, enquiries and proceedings under the Samhita, including so and so things, and may be held in electronic mode by use of electronic communication or use of audio video electronic means. എന്തെങ്കിലും പറയാൻ വിട്ടുപോയിട്ടുണ്ടെങ്കിൽ and I will invite your attention to that Roman letter 1 there. Issuance, service and execution of summons and warrants. How a warrant can be executed. A person can be arrested through electronic mode.
That is up to station. From the court up to station. They can download it and proceed with further actions.
With this, I may conclude. But before concluding, I may say a few words. See, during these 9 hours, about 9 hours, what I have what I have attempted to do is only to make you aware of the important changes only in the BNSS, brought in under the BNSS. Then many of these provisions are new provisions. It contains they contain gray areas which need interpretation by the constitutional courts. Till then, everybody can interpret these provisions in his own way. But what I have said or we have said here is not on these points or issues is not something final or not conclusive. As I stated, till the High Court of the Supreme Court, Constitutional Courts interpret that provisions and say something. What we have said is not final or conclusive, not even advisory. Not even advisory. I have only made an attempt to give you some practical insights into the new provisions and make you aware of these provisions and give you some insight so that you can think on these provisions from different angles. Different angles you can think of. That is the only thing I have made. Thank you. Thank you for the patient hearing for these 9 hours. Thank you.
I think you had given the clap a bit early that we cannot undermine the commitment, the dedication the SAR has put in for the last 9 odd hours. So the way in which he explained it and simplified it and ensured it the newly introduced provision may not be a source of headache for you in future. And rather than that, his bundle of experience spanning for more than 33 years as a trial judge, he put in all those experience and had found the solutions based on those experience. The knowledge he has shared, he magnanimously shared with all of us that you must also be aware of the fact that we may not get a person better than His Lordship Justice R. Narayan to enlighten us regarding these changes introduced because he is that much familiar with the old code and compared its scores so scrupulously with the new code. So that is the mastery of that is the speciality of this resource person. And Sir was so magnanimous, kind enough to accept our invite, come to the academy to enlighten all of us. And despite sharing dice with Sir for more than 10 classes on each topic, I am just a little bit wonder about the fact that each day he comes with some new ideas. That is very wonderful aspects as regards Sir. So with deep from our heart, we express our gratitude to His Lordship Justice R. Narayan.
Thank you very much.
Let's break for the lunch and we can reassemble by 2 o'clock. And before that, you may please come prepared for a photo session at 1:50. So do it with that much kind of stiffness.
150
150.
again.
Sir. Good afternoon, all of you. We are getting into the last phase of our 2 days intense training, and in this session, these two sessions, we will deal with Bharatiya Nyaya Samhita and Bharatiya Sakshya Adhiniyam, and to enlighten us about these two criminal statutes. So we are fortunate to have the presence of His Honorable Mr. Justice K. Abraham Matthew. Sir need no introduction at all. A very erudite judge, a very exceptional academician with proven track record. With all humility, I invite Sir to the academy and simultaneously request him to commence the class straight away.
Good afternoon, dear friends. This afternoon we are discussing the changes that have been made in two acts, that is, Old Indian Penal Code and the Indian Evidence Act. As you all know, Indian Penal Code is a substantive law and the other one is a procedural one. Some changes are only cosmetic in nature, but the other provisions changes that have been effected in the new acts, they are very drastic. And as you all know, I saw someone carrying a book that is three major criminal acts. And that prompted a junior advocate. She made a comment, a lady junior advocate. I thought that Indian Evidence Act was applicable only in criminal courts. And now only I understand that Indian Evidence Act is applicable in civil proceedings also. The reason is that this Indian Evidence Act is always seen together with Indian Penal Code and the CRPC. So even now, I think the impression of many advocates and including legislators is that Indian Evidence Act is a criminal statute. It's not like that. We can say that it is a secular statute as we call the word secular. It is not confined to the criminal proceedings. Okay, so let us start with this Indian Evidence Act, that is now we call it Bharatiya Sakshya Adhiniyam. Adhiniyam actually means act, a statute. There is no magic in that word. First, we shall see the changes made in this new law. Thereafter, we shall discuss the impacts the changes will make. Indian Evidence Act actually had a preamble. The word preamble was there just before the long title of the statutes. That word preamble is now omitted. The word preamble is not so in the BSA. It does not make any difference. But See, the Indian Evidence Act preamble, what is the long title of the Act? Whereas it is expedient to consolidate, define and amend the law of evidence, it's hereby enacted as follows. That was the contents of the preamble. That contents is still there. That is the long title of the statutes. And now it is, actually it runs like this. Whereas it is expedient to consolidate, define and amend the law of evidence. Then, an act to consolidate and to provide for, this is how it runs now. An act to consolidate and to provide for general rules and principles of evidence for fair trial. So the phrase general rules, we cannot see in the Indian Evidence Act. So that is a new phrase introduced in the BSA. What does it mean? What is the significance of this phrase general rules? General rules actually means it's indirectly tells us that the rules of evidence contained in this BSA, they are only general in nature. The antonym is special. General opposite special. So it just reminds us that there are special rules apart from the rules provided in the Indian evidence in this BSA. Where will you find this general special rules of evidence? You can see these special rules of evidence in other statutes, including CRPC, the old CRPC, BNS now, then Registration Act, Bankers Books Evidence Act, CPC. So 90% of the statutes we can say have special rules of evidence. And what is the special rules of evidence in the CRPC or the CRPC? What is the special rule of evidence? Section 162 is a classic example. A statement made to a police under Section 161 CRPC is not admissible except for certain purposes mentioned in the statute itself, the section itself. So that is a special rule of evidence. Sections 292 and 293, admissibility of certain reports. That is a special rule of evidence. And CPC Order 26 Rule 10, report of a commissioner forms part of the records of the case. So that means it need not be proved. Then Section 49 of the Registration Act, a compulsory registrable document which is not registered cannot be used to prove the transaction. Bankers Books Evidence Act, certified copy of a private document is admissible. So all these special rules, what is the significance of the special rules? Special rules of evidence will prevail over the general rules of evidence. So it tells us, at the beginning itself, the BSA tells us that these rules are only general in nature. If there are special rules of evidence, those provisions will prevail over the general rules. This is that was so even before BSA. Even under the Indian Evidence Act, it was like that only. This only reminds us restatement of the old law. That's all. Then the other phrase we can see, a new phrase which is used in the Indian Evidence Act, BSA, is that contains principles of evidence for fair trial. Does it mean that the provisions of the Indian Evidence Act, the old act, did not contain provisions for principles of fair trial? Does it mean so? It does not mean so. It also again tells us or reminds us that the intention, the object of these provisions is to ensure fair trial. That is a fair trial. And why that fair trial, this concept of fair trial is introduced in the Evidence Act? There must be one reason. What is that reason? The reason is that in 1872, you won't find 72 acts, Indian Evidence Act, you won't find such a phrase. The reason is simply this. There was no constitution in 1872. The constitution came into being only in 1950. So after 1950, the concept of fair trial, where is it stated? It is contained in Article 21 of the Constitution. Right to life and liberty is part of it. So this again is stated in this preamble or this first part only to remind us that the object of the trial and the rules of evidence framed for it is only to ensure fair trial. That's all. No other significance can be attached to these changes that have been made in the BSA. Then, Indian Evidence Act had how many parts? 3 parts. But the present BSA has 4 parts. 1 part has been added now. And the Indian Evidence Act had 11 chapters, but BSA has 12 chapters. The 12th chapter forms part 4. Sorry, that is not actually, that is in part 4. That is chapter 12, repeal and savings. There is only one section in chapter 12, that is repeal and savings. So, initially I told you that Indian Evidence Act is part of a procedural law. And the ordinary rule of interpretation is what? IPC is a substantive law, BNS is a substantive law. Substantive law is always prospective and procedural law is always retrospective. What does it mean? It only means that the provisions in the new enactment are applicable even to pending proceedings. So going by the general law interpretation, even to the proceedings now pending, the provisions in the BSA Act would apply. But it is not so because the provision in this section 170, that is repeals and savings, clause 2, notwithstanding such repeal in the Evidence Act, if immediately before the date on which this adhiniyam comes into force, 1/7/2024, there is any application, trial, inquiry, investigation, proceeding or appeal pending, then such application, trial, inquiry, investigation, proceeding or appeal shall be dealt with under the provisions of the Indian Evidence Act as in force immediately before such commencement as if this adhiniyam had not come into force. Such slight change is there. So, to a pending matter, suppose a trial is pending in a court, an application is pending, the section 125 CRP is an application is pending, then it is not via provisions of the BSA, but the provisions of the Indian Evidence Act that would apply. That is, they will continue to be in force for that purpose. That is only change. So we have to bear in mind that this is the effect of the changes that have been made in the BSA. Okay. Now, there were 185. How many sections were in the Indian Evidence Act? 100? Then what about some insertions? After 1872, some provisions were incorporated. They were inserted, 113A, 114A, etc., etc. So, including those provisions which were inserted later, there were 185 sections in the Indian Evidence Act. But in the BSA, there are only 170. The reason is very simple. Some provisions in the Indian Evidence Act have been clubbed and brought under a single provision in the BSA. We will see it later. That is the reason why there is a reduction of the number of sections. Not that many major change has taken place now. And Now there are only 170 sections instead of 185. And one of the important features of BSA when compared to this Indian Evidence Act is that BSA has a schedule at the end of it. There was no schedule attached to the Indian Evidence Act, but now there is a schedule attached to the BSA. What is the significance of this schedule? We shall see in the course of our discussion. Then certain provisions have been omitted. Certain provisions which you can see in the Indian Evidence Act do not find a place in the BSA. They are Section 22A, oral evidence as to the contents of electronic record. The reason is that it is otherwise taken care of in the BSA. Section 82, presumption as to documents admissible in England. We are not a colony of England now, Britain now. We are a sovereign country. So we need not depend on any rules of evidence in English. Section 88, presumption as to telegraphic message. That has been omitted now. The reason is very simple. Why? There is no telegraph now. Even that department is not there. Earlier it was a post and telegraph. Now it is only postal department. So there was a presumption attached to this telegraphic message that was contained in Section 88. So since telegram is not there, that provision need not be there in the new statute. So that has been deleted, omitted. Logical. The last one, 113, proof of cession of territory, not longer necessary. 166, power of jury or assessors to put questions. That is also not necessary because we have abolished jury system. Long ago we abolished it. So these omissions are logical. Only 5 sections have been omitted, and it is logical that they were omitted. Now we can say that there is one section which is new. That is the section 61. Section 61 refers to electronic or digital records. Nothing in this adhiniyam shall apply to deny the admissibility of an electronic or digital record. That is the subject matter of this section 61 now. We shall see it later when we consider the impact of the changes brought out so far as electronic records are concerned. Then some sections have been clubbed. Sections 3 and 4 in the Indian Evidence Act, mainly dealing with the definitions, they have been clubbed and brought under one section, that is section 2 now. So that means section 2 is the dictionary in the Act. It is the dictionary of the Act because it contains the definitions. So it is the dictionary of the statute. Then section 24, 28 and 29 now come under one umbrella, that is section 22. 24, section 24 related to what? In the Indian Evidence Act. Confession. The 28 also confession, 29 also confession. 24 dealt with facts which vitiate confession. Facts which vitiate confession. And 28, the effect of removal of the vitiating facts. And 29, confession made under the promise of secrecy. So it is quite natural that they are brought under one umbrella, that is the section 22 now. Then section 25, 26, 27. All these sections are now put under one section, that is section 23. You know section 25, confession to police under Indian Evidence Act. Section 26, confession to anyone other than police whilst in the custody of the police. And section 27, as you all know, it is discovery of facts. All these sections have now been brought under one section, that is section 23. And now there is no longer section 27 recovery, it is only 23 recovery. Section 45, Indian Evidence Act, spoke of expert evidence, and section 45A, electronic evidence. Now they fall under only one section, that is section 39. So 45 and 45A clubbed. Section 74 Indian Evidence Act related to public documents, and section 75 private documents. Now they come under only one section, that is section 74. A come under section 41. 74 and 75 now form section 74. Then section 126 Evidence Act dealt with professional communication, prohibition of disclosure of professional communication. And section 127 said that those provisions are applicable to interpreters also. So it was in the nature of a proviso to section 126, and now they together constitute one section, section 132. Then sections 141, 143 and 146, all of these three sections dealt with leading questions. So in the Indian Evidence Act, there were three sections dealing with leading questions. And now there is only one section, section 146. But the contents is the same. And I have already told you that section 24 Indian Evidence Act, they give this, that section gives us the facts which vitiate confession. Okay? And now we can see the changes, insertions that have been made. Some modifications or insertions have been made in the provisions in the Indian Evidence Act so far as BSA is concerned. We shall see the changes. The first change is in the definition of documents under section 3 under the Indian Evidence Act. Now it is section 2D BSA. Definition of documents has been changed now, or there is an insertion in it. And under the Indian Evidence Act, the definition of document did not include electronic records. Electronic record was not a document under the definition of documents in the Indian Evidence Act. That is why there is a deeming friction in section 65B, etc., 59, etc. And who said so? The authoritative pronouncement of the Supreme Court in Arjun Pandit Rao. Arjun Pandit Rao. Now, a change has been made in the definition of documents in the BSA. We shall see what it says now. Section 2D. Document means any matter expressed or described or otherwise recorded upon any substance or means of letters, old one, at the last, and includes electronic and digital records. So electronic and digital records, they are also documents under the BSA now, because the definition included them. It has been included in the definition. Remember, two phrases have been used or two words have been used, which are the electronics and digital records. Electronic records and digital records. What does it indicate? It indicates that they are not the same. It is not a synonym of digital records. Is not a synonym of the word electronic records. They are different. They are differently dealt with, which has some significance. Now, section 24. Sorry, section 4. Section 4. Section 4, the old section is the section 6, register. That is of the same transaction. And one word has been inserted in the old section 6, that is, what is that word? Relevant facts. The old section 6 read like this: facts which though not in issue are so connected with a fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. The principle contained in this section is register. Okay, so section 6 spoke of only fact in issue, only facts which were connected with the fact in issue. Indian Evidence Act spoke of two types of facts. One was a fact in issue, the other relevant facts. You can see it in section 5. You can adduce evidence only in respect of facts in issue or relevant facts. So in all other sections, almost all other sections are dealing with the relevancy, starting from section 7. So section 5 speaks of, Indian Evidence Act speaks of fact in issue and relevant fact. Section 7. Section 7. Facts which are the occasion, cause or effect immediate or otherwise of relevant facts or facts in issue. So again, facts in issue and relevant facts. Section 8. Again, constitutes any fact is relevant which shows or constitutes a motive for preparation of any fact in issue or relevant facts. So almost all the sections are dealing with the relevancy identical provisions. They spoke of facts in issue and relevant facts, but section 6 did not. Now section 4, it contains the word relevant fact also. So the principle of register applies not only to facts in issue, but to relevant fact also. Has it any significance? It has some significance. Section 6 is a special, it is a special in as much as it is an exception to rule against hearsay. Hearsay evidence is not admissible under section 60. Direct evidence only is admissible. Hearsay evidence is not direct evidence, so it is not admissible under section 60. One of the exceptions you can see in section 6. Though it is hearsay, it is admissible. Okay. So take a case where it is a murder case. In the ordinary case, the only fact in issue is whether the accused committed murder. So only facts which connected with the fact in issue, that is murder, was admissible under section 6. There may be other relevant facts Many facts are relevant. Whether he is absconding after the incident, whether he made preparations for the murder, all these are relevant facts, though not facting issue. And under section 6, the facts such as preparation, facts such as subsequent conduct, they were not, in respect of those facts, risk stay was not applicable. But now, introduction of this particular fact, particular phrase, relevant facts, they are also admissible under section 6. What does it mean? The scope of risk stay has now been expanded. And you know that the general law is that when an exception is provided, it should be interpreted strictly. It should be confined to that particular phrase. With the introduction of this phrase, relevant fact in section 4 in BSA, it has enlarged the scope of this particular risk stay now. What does it mean? Even remote facts can be proved under section 6. See, when this is an exception to section 60, here say, its scope should have been restricted, and that was restricted under section 6. Now, that restriction has been taken away, and in certain cases, this will have much impact. That means a remote facts, which are hearsay, also become admissible under section 4. That is very dangerous, so far as sessions cases are concerned, criminal cases are concerned. And it appears that the person who drafted the bill thought that James Stephen accidentally omitted to include it. That was not so. Because I have already told you the law. That means it should be a restricted application only. Unfortunately, it is there. It is there much impact on sessions cases, and that will be unfavorable to the accused. That will be unfavorable to the accused because remote facts, they also can be proved under section 4 now. Okay. Now, another section in which there is an insertion is section 24, old 24, present 22 BSA. That is, facts which vitiate confession. Only three facts were mentioned in section 24. They were promise, threat, inducement. So, section 24 only contained three facts, that is, promise, inducement, threat. Now, there is another one also, that is coercion. Coercion actually, it is an idea borrowed from where? Coercion. Law of contracts. That particular word you can see in contract acts, right? It was not there in the Indian BNS Act. As I think the difference between threat and coercion is that, there is only a difference in degree. There is difference in degree, but it has much significance also. Now, coercion also is introduced. The next section in which some changes have been made is section 30 Indian BNS Act corresponding to section 24 BSA. Section 24 BSA. And that deals with what? Confession of co-accused. Admissibility of confession of co-accused. And Indian BNS Act, or even under the BSA, read section 24 or 30, when more persons than one are being tried jointly for the same offense, and a confession made by one of the persons affecting himself and of some other persons is proved, the court may take into consideration such confession as against the other person as well as against the person who makes such confession. So what was necessary? What was the condition for invoking section 30 joint trial? Only when the person, the accused who made the confession, and the person who is sought to be the accused who is sought to be robbed in are tried jointly, section 30 is applicable. So in the case, suppose the co-accused is dead or is absconding, what would happen? Section 30 is not applicable. Now, as you all know, you must have already come across, or your attention has been brought to the change that has been made in the BNSs. There is a concept of in absentia trial, just like civil case. Just like a civil case, the accused is not there. We don't want to compel them to appear. Let them go. Even in his absence, trial will take place. That is called in absentia trial. Some modification made under section 21, section 299 and all. So in absentia trial is now valid. Presence of accused is not necessary. Then accordingly, change has been made in Indian Evidence Act also. Now the section is 24, joint trial, confession of co-accused. And in accordance with the change that has been made in the BNSs, the change that has been made in BSA is an explanation has been added. Explanation 2. Explanation 2. Section explanation one was there in the Indian Evidence Act also. Explanation 2. A trial of more persons than one held in the absence of the accused who has absconded or fails to comply with the proclamation under section 84 BNSs shall be deemed to be a joint trial for the purpose of this section. What does it mean? Even though he is absent, he will be deemed to be present. A deeming provision has now been made. Deeming provision is necessary when it is not really so. So because it's a fiction. It is a fiction. Reality is not so. He is not present. But he will be deemed to be present under the BSA now. Provided certain conditions are there. Proclamation, absconding, etc. Proclaimed offenders, etc. And there were only 2 deeming provisions in the Indian Evidence Act. Which were they? There were 2 deeming provisions in the Indian Evidence Act. Section 65B, deemed documents. Computer outputs are deemed documents under section 65B. One more deeming provision is there in the Indian Evidence Act. Section 119. If a defendant person gives his evidence in writing, then it will be deemed to be oral evidence. It will be a deemed oral evidence. So there were 2 sections, deeming provisions in the Indian Evidence Act, section 65B and section 119. Now they form section 63 and 124. And in addition, we have another deeming provision in section 24, deemed joint trial. Section 45, everyone knows in the Indian Evidence Act, related to what? Expert evidence. Expert evidence. And in respect of any subject, you could not have adduced expert evidence under the Indian Evidence Act. Only in respect of 5 subjects. There were foreign law, art, science, finger impressions, handwriting. Now a change has been made in the corresponding provision, that is in section 39, and it says that after the words of science or art and before the words or as to identity of handwriting words or any other field. So that what does it mean? You can adduce suspect evidence in respect of any field. What may be the reason? What may be the reason? The reason is very appears to be this: developments take place in the society, especially in the fields of science and technology, in quick succession. In quick succession. In ancient times, it took 50 years, 100 years for a change in science and technology, for an invention. And inventions mainly were made during which period? War. First World War, Second World War, they resulted in many inventions. Right? So it was a necessity then. Now it's not so. Now in the fields of science and technology, developments take place in succession. The science and technology we have now before us may not be the science and technology tomorrow. Even in a few days, the science and technology may change. So we cannot say, we cannot visualize what new field will come into place tomorrow or after a few years. That's why a new field has been, just like a residuary clause, any other field. Suppose a new field comes into existence tomorrow, you can adduce suspect evidence in respect of that field to enable it. That phase has now been introduced in section 39. Then section 57 finds which the court may take judicial notice of. All the section 57 corresponding to section 52 BSA. Some changes have been made. 57 plus 1 Indian Evidence Act. After all laws in force in the territory of India, so section 57(1), the court shall take judicial notice of the following facts. All laws in force in the territory of India. That is what we find in the Indian Evidence Act. Now that has been changed. It says that including laws having extraterritorial operations, that will be included. Because we know the changes in law reflect what? The changes in law reflect what? The changes in the society. The changes that have taken place in the society. Right? So Indian Evidence Act, the BSA has taken notice of the changes that have taken place in society after 1872. And after 1872, we know that, especially after globalization of 1990s, we know that what happens now, sitting in America, one can commit an offense in India. That principle has already been recognized in the IBC and the CRPC also, but it is more so now because certain provisions are there in penal code in respect of this or dealing with offences committed outside India. That is a software because of the software revolution. So we have inserted this word, including laws having an extraterritorial operation. Now, another one is international treaty or agreement. International treaty agreement newly inserted in section 52(1)(b). So the court shall take judicial notice of international treaty agreement or convention with country or countries by India, or decisions made by India after at international associations or other bodies. Why that did not find a place in the Indian Evidence Act? That was not seen. That was not one of the items the court shall take notice of under the Indian Evidence Act. But now the court is bound to take notice of it, because the word used is a shall. What is the reason why it did not find a place in the Indian Evidence Act? Indian Evidence Act was enacted in 1872, and there was not even the concept of international law. There was no international body. And international body came into existence only after the First World War, League of Nations. And that failed. And UNO came into existence after the Second World War. And now we have international laws. And as you all know, it is a law governing nations. We are not directly parties to international organization. Only the state can represent. Okay? So we have got International Court of Justice at Hague. A citizen cannot go there with a complaint. Only a member state can go there. And we know that there has been litigation, there have been litigations between India and Pakistan. And we have won all the litigations there. Okay? So, international law is a new idea which came into existence after World Wars. And there is international law, though it cannot be enforced in municipal courts, that is domestic courts. We are bound to make changes in our municipal laws to make our laws in conformity with international law. And where can you find the international law except the UN Charter? There will be documents prepared by various wings of the United Nations organizations like Human Rights Commission, Children, then CEDAW, and their documents after study, they prepare documents, and those documents become applicable to a nation like India only if we subscribe our signature. So they will prepare a document and they will leave it open. It is open for every member state to subscribe. The moment we subscribe our signature to it, we become bound to make changes or new laws in our state. And that's how we made certain changes or new enactments we made, one of which is Juvenile Justice Care and Protection of Children Act, on the basis of the Convention on the Rights of Child. So, international laws cannot be enforced in the municipal court, but the principles are applicable. And there are at least two instances where international laws were taken notice of by the courts in India. One is under Order 21 Rule 7, under Order 21 Rule 37, the decree holder has to prove the means of the JD for sending him to jail. And CPC speaks of the JD has had means after the passing of the decree. Right? And that has now been interpreted by the Kerala High Court. First one was the Kerala High Court by Justice V.R. Krishnaiah. It means that means current means. Because international law says that a person, because of his poverty, is unable to discharge his debt, shall not be sent to jail. He shall not be present. That principle was adopted by Justice Krishnaiah and said that means current means. And another occasion where the international law was taken notice of by the Supreme Court is Vishaka case. Harassment of women at workplace, prohibition. The Supreme Court took notice of the CEDAW, Convention on Elimination of All Forms of Discrimination Against Women, and said that there is no law in India. There is no special law in India. So, invoking this international law and the provision in the Constitution of India, we declare that women should be protected from sexual harassment at workplace. And till the legislation is made, our directions will be the law of the land. Okay? So even though international law cannot be enforced, the principles were borrowed, adopted by India, and they were. So now we are bound to take notice of international law. International law. Okay. So actually, uh, the words used are international treaty, agreement, or convention. Actually, they all mean the same thing. They are all agreements. But at the UN, it is a very elevated forum, United Nations. We do not use the word agreement ordinarily. It is not used. The word agreement is not ordinary use. You will not see in this UN papers. The words used are convention, conference, treaty. And there is one treaty to which India is not a party. What is that? Which one is this? Death penalty abolition. We have not subscribed or signature to it. So that means death penalty can be imposed in India. If suppose we subscribe to our that particular treaty, then section 302 we have to make changes. Death penalty can be awarded. So now we are bound to take notice of the international conventions, treaties, or agreements, etc. And that is now we will see it in section 52 plus 1b. Then some provisions have been omitted, some have been introduced. They are not of much consequence, and instead of the word country, the word state is used, because we do not use the word country now. In UN we say that state, member state, India is a state, instead of saying that India is a country. So it is a state, member state, we say. Some changes have been made. Then there is a change with regard to our those who are practicing so law, that is, and of all advocates. The court was bound to take notice of all advocates, attorneys, proctors, wakils, pleaders, etc. Now, section 52K, only one word is used: advocates. In the place of all these, that is, attorneys, proctors, wakils, and pleaders. Instead, only one category is there, that is advocates. We know that there is no wakil now, the phrase is not used. Pleaders only confined to this government advocates. But there is one impact. I don't want to discuss it now, but there is one impact which the legislature was not conscious of, because the change that has been made. Because a change has been made in BNSS also. The word pleader was defined in the BNS Act, that now has been omitted. It has some impact. I don't want to discuss it now, because BNS is already you have discussed. The other changes are cosmetic in nature. Then another change, major change, is in old section 62, now section 57. Primary evidence. So primary evidence, and you all know that primary evidence is the document itself. Document itself. That means the original document only is called a document in the Indian Evidence Act. A copy is not used there, is not a document. It is only a copy. And electronic records, with the introduction of the words electronic records or digital records in the definition of documents, some changes have been made here also. There are some explanations have been added. Apart from the explanations already were in section 62, 57 BSA now, those explanations are 4 to 7. 4 to 7. So there are 4 explanations added now in section 62, that is present section 57. It's explanation 4. Where an electronic or digital record is created or stored, and such storage occurs simultaneously or sequentially, in multiple files, each such file is a primary evidence. So what does it mean? Where an electronic or digital record is created or stored, it can be created or stored, just a creation only, or it can be stored, in the appropriate place, and such storage occurs simultaneously. What does it mean? Or sequentially in multiple files. So there should be multiple files. The contents should be stored there. The storage should take place simultaneously or sequentially. There is a difference between simultaneous and sequential. What's the difference? Simultaneous means at the same time, and sequentially means one after another, in quick succession, right? We can compare it to making of idli. അല്ലേ ഈ ഇഡ്ഡലി പാത്രം നമ്മൾ മലയാളത്തിൽ പറയില്ല ഇഡ്ഡലി തട്ട് അല്ലേ and how do you make idlis? There will be number of idlis can be made at the same time. You just place it on the oven and all the idlis will be formed at the same time, simultaneously, but each individual idli will be independent. So that is simultaneous, but at the same time there are several idlis being made. So that is simultaneous. But you know this doshakallu, big doshakallu at these parties, functions, you must have seen it, big one, and they make doshas. Then one after another they will pour this particular dosha maavu, right? So it is a sequential. So that's the difference between simultaneous and sequential. In both cases, all of them are, or each one is primary evidence, just like each dosha and each idli is independent and it has its own identity. Then, explanation 5. And I may be excused. I am not an expert in this technical field. I do not have in-depth knowledge in this software matters. And our John Varghese and Krishna Kumar, they are there. They may be able to explain in a better way. Okay, but with my limited knowledge, I am explaining this. Explanation 5. So, explanation 4, where an electronic or digital record. The subject matter is electronic or digital record. We have seen the definition, both are used. And here explanation 5 also, where an electronic or digital record is produced from proper custody. Such electronic or digital record is primary evidence unless it is disputed. So what does it mean? When an electronic record or digital record is produced, which is purported to be the original one, it will be treated as an original, which is only a primary document, which alone can be a primary evidence if it is produced from proper custody. And proper custody is not defined in this provision, but I will swear this there, old section 90, proper custody for the purpose of this section. But such a phrase is not there. There is no explanation attached to section 57 now. So it is a question of facts left to the discretion of the court, whether it is produced on proper custody or not. And what happens where an electronic or digital record is produced from proper custody? Such electronic record is primary evidence unless it is disputed. So suppose it is a mobile phone, I am taking a photo on this mobile phone, and the one which I have taken, that means which has come into existence for the first time, that is the original one, it is a primary evidence. And I produce it, this is the one I took on my photo, my mobile phone, then that means mobile phone belongs to me, that means I am the proper custodian of my phone. That is sufficient. But the other party can dispute it. He can say that it is true that it was taken on his mobile phone, but that was transferred. Or they can say that it was taken in another by another mobile phone, and that was transferred to my phone, and I produce it as if it is the original one. So if it is disputed, then it is not a primary evidence. It has to be proved that it's a primary evidence. That is all what it says. So there is a presumption that if it is produced from proper custody, it is a primary evidence. Nothing more. Now section explanation 6 we can leave for the time being. Explanation 7. Where an electronic or digital same phrase is stored in multiple storage spaces in a computer resource, is such automated storage including temporary files is a primary evidence. So in a if there is a facility of multiple storage in a computer resource, then if the storage takes place automatically, not manually. So it should be automatic one. So if the storage takes place automatically, then that means each such automated storage is primary. Okay? Each one. So these are all technical matters which have to be proved, and sometimes advocates may find it difficult to challenge or how to cross-examine. Okay? So you will need the help of a technician, expert. Okay? Under the BNSs that was possible. An expert could have cross-examined a party, a witness, and our Dr. Umadatan, he had cross-examined certain witnesses in sessions cases on behalf of the state. And because of the change that has been made in the BNSs, I think that provision is not applicable, 301. Because the definition of the pleader has now changed, only an advocate can do it. But I think a general law may sometimes permit. The Supreme Court has said that, okay, you can do it. You can understand. Because CRPC, the provision is that only a public prosecutor can conduct prosecution. Okay? His junior can conduct. But only under the instructions of the senior. And he also should be an advocate. But that was not necessary because of section 301. The word used as pleader, and pleader was defined into Q in CRPC. That has now been omitted. So that is the impact of the change that has taken place in this BNS. Okay, forget. So explanations of 4, 5, and 7 we have considered, and all of them speak of electronic or digital records. But explanation 6 stands out. Explanation 6 does not speak of electronic or digital record, but of video recording. That difference you may note now. Where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each stored recording is the primary evidence. What does it mean? The classic example is the present recording of this discussion. I think it is now YouTube, it is available. Everyone who is watching these proceedings, they will get it. It is from the source. From the original source, they are getting it. And suppose they record it. Each one is a primary evidence. Suppose a disputer or somebody files a defamation suit against me, saying that, yes, he has used some defamatory words against him, and what will be the evidence? Earlier, the evidence was that the one who records it in the Judicial Academy. Now, it need not be so. Anyone who has got it on the YouTube can produce it and say that this is because of section explanation 6. This is a primary evidence. Live broadcast. Now, you see, when funerals take place in almost 60% of the families in Kerala, youngsters are abroad. They are abroad. And here, People like me, old people, are left alone in our houses. And an old man dies. He has 5 children. One is in New Zealand, the other is in Australia, another one is in America, another one is in Belgium, another one is in Britain, and so on. Necessarily, he has to be given a decent burial, right? For that, why should that man come here, children? They will send money, and there will be even money. Okay? And what they will do, and it will be broadcast live. Live broadcast will be there, and one man will cry sitting in New Zealand, the other will cry in America, the other one in Belgium, etc. This is live broadcast, and explanation 6 is applicable. So it's sufficient for the American to bring that one. Yes, this is the speech that was made at the funeral. So that is explanation 6 alone speaks of video recording. The other explanations speak of electronic or digital records. And we can see that just like the Indian Evidence Act, in BSA also there is a provision which says that any expressions which have not been defined in this act, but defined in Information Technology Act, the other statutes, BNS, etc., they will have the same meaning assigned to them. Okay? Electronic record is defined in the Information Technology Act, but digital record is not defined. And it's not defined in the BSA or in the Information Technology Act, no other statutes. So what do you mean by digital record? What's the difference between electronic record and digital records? The difference, I told you that I'm not an expert in the field. I am told that when you create a document, the word creation is there, used now in the Indian BSA, which was not there in the Indian Evidence Act, creation. When you create a document, that means the one which comes into existence for the first time is the original one. So when you type something on your computer, it is an electronic record, and that is an electronic record because that document came into existence for the first time when you prepared it on the computer, laptop. Suppose it is already available there just like this book, and you scan this, a physical book copy document, and you convert it into an electronic record. Though it is an electronic record, it is called digital record because there is a conversion from physical record to electronic records. I am told so, and if I am wrong, you may kindly bear with me. This is the change that has taken place now. But the one digital record that is taken for the first time alone will be primary evidence, not everything. Unless all these are taken simultaneously, sequentially, as we have already seen. And what is the impact of this definition, explanations in the primary evidence definition? What is the significance of it? What is the significance? Why is said that numerous things are there in primary evidence? There are numerous items are formed now primary evidence. What is it? That means you can produce them as evidence, tender in evidence, or without a certificate. If it is a primary evidence, no certificate is necessary. A certificate is necessary under section 65B, now section 63, only if it is a secondary evidence. So primary evidence, no certificate is necessary. That is the significance of a primary evidence. So now there may be several primary evidence, just like under the Indian Evidence Act by a uniform process. If a document is prepared by a uniform process, just like using a carbon paper, you prepare a mahasar, both are primary evidence. Though in the ordinary parlance we call it a carbon copy, in the legal parlance it is not a copy but it is a document because it has an original primary evidence. That is the effect of these changes that have been made in Section 57 BSA now. But what can be gathered from these provisions is this: unless the advocate is alert, any copy can be introduced, secondary evidence can be introduced as primary evidence. You must raise your objection unless it is disputed. That explanation we have seen, explanation 5. So unless it is explained, unless it is opposed, it is disputed. That means what? It will be treated as a primary evidence, even though it is not a primary evidence. Okay, so that is the role of the advocate. They should be alert when the document is tendered in evidence. So that means what? You have to do homework. Without doing homework, you cannot come to a court to challenge these documents, because you have to oppose it the moment it is tendered in evidence, not thereafter. Then it becomes final. So advocates should be alert now. Now section 63. Section 63. Section 63 Old Act, now section 58 BSA. Secondary evidence is defined. Secondary evidence is defined. And secondary evidence, there were, how many items were there? 5 items. Now there are 8 items. How did the section 63 start? In the Indian Evidence Act, secondary evidence means and includes. What does it mean? Rule of interpretation. It is exhaustive. That means you cannot add an item to it, you cannot delete anything from it. It is exhaustive means that is all what is meant. Now section 58, which defines the secondary evidence, includes. That means it is not exhaustive. I don't know whether the person who drafted it had an idea that if some changes take place in the future, that also should be there. I don't know. Okay, so it is not exhaustive now. Anything can be added. It is left to the discretion of the court. Oh, this also is a secondary evidence. Okay. Now there are 3 items added to it. That is clauses 6, 7, and 8. Items 6, 7, and 8 now have been added, which were not there in the Indian Evidence Act section 63. The first one is oral admission. Oral admission, as to what? Remember that section 63 speaks not of admissions under section 21 of the Evidence Act, but it speaks of contents of documents. The ordinary rule is that the contents of documents shall be proved by producing the document itself, or its secondary evidence if permitted. There is no question of adducing oral evidence. That is the oral evidence section 59 Old Act. All facts as such, contents of document may be proved by oral evidence. There was only one exception. Now, this says that oral evidence, oral admission as to the contents of a document is admissible. And this was there even under the Indian Evidence Act, section 22. When oral admissions as to contents of documents are relevant, section 22. Now it is now available in section 58 as a secondary evidence. Secondary evidence. That means, if no direct evidence is available, what can you do? You can prove that the opposite party has admitted the contents of the document. Then it will be a secondary evidence. There is a dispute, take a case where there is a dispute between 2 brothers. The elder one files a suit for partition of the properties belonging to their father. He alleges that he died intestate. The small brother is the defendant, and he appears and raises a contention that it is not true that he died intestate. but he has bequeathed all the properties to me. All the properties to me. And if the elder brother had made oral admission as to the contents of this will, it is secondary evidence now. And suppose after the execution of the will, the elder one, the plaintiff, came to know about it, and he goes to his leader of his community, vicar of the church, president of NSS, secretary of the SNDP or any other community, and he makes a complaint. My father has done an injustice. He has executed a bill on 1/1/2021, bequeathing all the properties to me, and he has not given any property to me, and there should be a decision on this. And the dispute, when this dispute comes to the court, this oral admission made by him that father executed a bill on 1/1/21, and by it he bequeathed all his properties to the brother, becomes admissible because it is a secondary evidence. That is the relevancy of it now. Now, written admissions. Written admission is another one inserted in definition of secondary evidence, was not there in section 63. At the same time, a written admission was admissible. How? Even though written admission did not find a place in section 63, written admission as the contents of the document were admitted in evidence because of the provisions contained in section 65. In section 65B, it says that if there is an admission writing as the contents of a document, then the latter part says that the original admission in writing is admissible as a secondary evidence. At the same time, such an item did not find place in section 63. So that is the question some people, some trainees or advocates used to ask me, why it is there. There was no explanation. We could not explain it logically, why it was omitted. Now, as in the nature of a clarification, they have introduced it in section 58. So written admission, or written, it is only logical now. It was already there. So oral admission, there was already a provision in section 22. And written admission, there was already a provision in section 65. And the last one is evidence of a person who has examined a document, the original of which consists of numerous accounts or other documents which cannot conveniently be examined in court, and who is skilled in the examination of such documents. This phrase you will see where? In section 65. In section 65G, you find this same exactly one. So even though this was not included as an item in section 63, we used to admit it because of section 65. So it was already there in section 65. So this only is these new items, they are only in the nature of clarification. It was these items were the courts used to admit these items because of section 65, even in the absence of those provisions in section 63. So it is only in the nature of clarification. Now the major change that has been made in BSA is in section 65B old. We shall discuss it later. Now we come to another section, section 108. Old 108, that is one of the two sections in the Indian Evidence Act which is started with the word provided, the other word being section 27. Ordinarily, no provision will start with the word provided because it always is that exception. So section 27 was an exception to sections 25 and 26. Section 108 was an exception to section 107. 107 dealt with what? Presumption as to a positive fact. That is, a person is alive. On the other hand, section 108 dealt with a negative fact that whether a person is dead. The question is whether a person is dead. Now, the only change that has been made is that the word provided is removed from that section. No other change. The legislature clubbed many sections which were in the nature of proviso, but I don't know why this section 107 and 108 were not clubbed. There is no logic in it. Okay. Then another section is 118, Old Act, now section 124 BSA. The Old Act section 108 is some mention was there as to the evidence given by or competence of persons who were lunatic, lucid in lunatic. And the word lunatic is now not used. It is derogatory now. മലയാളത്തിൽ എന്ത് പറയുന്നു? വട്ടൻ, ഭ്രാന്തൻ. ആ വാക്ക് നമുക്ക് ഉപയോഗിക്കാൻ പറ്റില്ല, derogatory ആണ്, നെഗറ്റീവാണ് അല്ലേ? Now the word used is person of unsound mind. So accordingly, change has been made in section 118, that is corresponding to section 124 BSA. Then another change that has been made is in section 165 or 168 now BSA. 165, what was the subject matter? The power of the court to put questions. The power of the court to put questions at any stage without any notice. And there shall not be any objection on the part of any of the parties. And even cross-examination was possible only if the court permitted to cross-examine on that particular point. So it could have been in any form. That means even leading questions the court could have asked. Even section 162 was not applicable to court when it exercised the power under section 165. Now, what was the provision? You can put any questions relevant or irrelevant. So the court could have any questions even if the fact was relevant or irrelevant. Now that has been omitted. 165. 165. That is 168. Old section 165. The judge may, in order to discover or obtain proof of relevant facts, ask any questions he pleases in any form, at any time, of any witness or the parties about any fact, relevant or irrelevant. That has now been omitted now. But that does not mean that the power of the court is restricted. That power is still there, I believe. It inheres in the court. So there are the changes that have been brought in certain sections. Now we are left with section 65B and the connected records, connected provisions, which you shall see after the tea break. Let's first examine these changes made in section 65B corresponding section 63 of the present Act. Now section 63. Just like section 65B. Okay. See, section 63, subsection 2. The conditions referred to in subsection 1 in respect of a computer output shall be the following, namely, the computer output containing the information was produced by the computer. So the word computer you can see at many places in section 63. And wherever you see the word computer, immediately after that, or computer device also has been added now. Computer or computer device. Communication device. Communication device. The word communication device is defined in Electronic Disinformation Technology Act. So there are many places. Then another word that has been introduced is the create. Create. We have already seen that the word creation means something which is brought into existence for the first time. For the first time. So when an electronic record is made, that you are creating it because it comes into existence for the first time. And at two places the word create or something, some derivative you can see. That is the first one is clause A subsection 2. That is, the conditions referred to in subsection 1 in respect of a computer output shall be the following, namely, the computer output containing the information was produced by the computer or communication device during the period over which the computer communication device was used regularly to create. Earlier it was store or process. Now the word creation also is there. And accordingly, in subsection 3 at the beginning, where over any period the function of creating, there was only storing. So the word create has been added in subsection 2, 63, subsection 2, clause A, and the word creating is added in subsection 3. Then, in subsection 4, subsection 3, you can see some items are given there. Pudhiya Act kando, section 63. New Act, section 63 BSA. Some items are mentioned, A to E. That's a modification. Made in the old section 65B subsection 3. That in standalone mode, computer system, computer network, computer resource through an intermediary. Some of these phrases are defined in the Information Technology Act. So that is an addition or modification made. Then another modification is in subsection 4. In any proceeding, or I will read the Indian Evidence Act first. In any proceedings where it is desired to give a statement in evidence, by virtue of this section, a certificate doing any of the following things, that is to say, along with it, that is to say, the following things, that is to say, 1, 2, 3, ABC. Some modification has been made there. Any of the following things, thereafter, after that phrase, the following is added. Shall be submitted along with the electronic record at each instance where it is being submitted for admission. That is an addition now. So what does it mean? In any proceeding where it is desired to give a statement in evidence, by virtue of this section, that is a certificate, that is a secondary evidence. Secondary evidence of an electronic record, if it is produced, that you want to prove the contents statement in it, then a certificate shall be produced. Now, what is added is, it shall be submitted along with the electronic record. Along with the record, at each instance where it is being submitted for admission. So, when it is admitted for admission, what is the stage at which should be produced now? Certificate. The certificate should be there when it is submitted for evidence, that means tendered in evidence. Because in Arjun Pandit Rao's case, the Supreme Court said that if you are not able to give a certificate produced at the initial stage, you can apply to the court at any stage, unless it causes prejudice to the opposite side, at any stage, and get a certified copy from the court, through the court. So now it is said that electronic record at each instance where it is being submitted for admission. So when a secondary evidence of an electronic record is submitted for evidence, that certificate should be there. That is mandatory now. It need not be when it is produced for filing. That is not necessary. Now, but the difficulty arises from the words used at each instance. What do you mean by each instance? What do you mean? Whenever it is, if you want to produce the same document several times, then at each instance it shall be there. But suppose you get a certified copy of a public document. Once it is, the certificate is there, it is always a certified copy. Whether you produce it in one case, several other cases, it is the same document, and it always retains the character of a public document. Why should you get a certified copy at instance? It will be there. It appears that this phrase has been used because the person had the idea that there may be cases where the certificate is separate from the electronic record, an independent certificate stating that the contents of this particular electronic document, which is annexed here to, is etc. etc. All these facts are there, right? That may be the reason. Otherwise, it is illogical. Because you know, when a probate is issued, what happens? Probate is nothing but a certificate. Certificate to the effect that the certificate certificate that the will, a copy of which is annexed to this certificate, is the last will and the original will, genuine will, right? Genuine is certified. So that means it is a certificate independent, and the will be, copy of the will be annexed to it. In such cases, once it is produced and you get it back, you cannot produce in another case again without a certificate. Merely because it was produced and acted upon by the other case, it is not admissible. That may be the reason, otherwise it is illogical. Illogical to say that at each instance. So whenever it is produced or submitted for evidence, tendered in evidence, that certificate should be there along with the electronic record. That is all what it means, I think. Then, now coming to after C, cross C, and say, remember, you read C, A, B, C. A, B, C. The certificate should deal with any of the matters to which the conditions mentioned in subsection 2 relate. What does it mean? Any of the advocates means what? Anyone. It can be anyone, not all. Anyone means anyone. And here it says that the certificate should deal with any of the matters to the conditions mentioned in subsection 2 relate. In subsection 2, how many conditions are there? There are 4 conditions. So going in the literal sense, it means that it is sufficient to comply with any of the 4 conditions. Is it that? Is it true? Is it the correct interpretation? Where will you get it? In Arjun Pandit Rao's case, the Supreme Court said that here any should be read as all. So even that Supreme Court decision was not taken into consideration. That was not noticed. That was the interpretation given by the Supreme Court. Because even before the drafting of the bill, that Supreme Court Arjun Pandit Rao was pronounced long ago. Now again come to the last part of subsection 4. It shall be sufficient for a matter to be stated to the best of the knowledge and belief. So we ordinarily see this phrase, to the best of my knowledge and belief. In where will you see this phrase? Affidavit prepared by an advocate, right? Suppose it is a dispute between father and mother of a child, and at the end of the affidavit, and you will say that the second respondent is our legitimate son, and the last part you will say, this is true to the best of my knowledge and belief. What is the difference between knowledge and belief? If knowledge is there, there is no question of belief. If knowledge is there, if you have knowledge about something, that means it's not a question of belief. You know it. Belief is there when you have no knowledge of it. But you believe. You believe. Right? So the Supreme Court in Arjun Pandit Rao's case, that it is sufficient to say that it is the best of my knowledge or it is the best of my belief. Either one do. Even that was not noticed in the BSA. Okay, these are some minor things we have to, it should occur to your minds. Then come to this changes. That is the important changes. Important changes. See, after 4C, clause C, you read, and purporting to be the old Act, Indian Evidence Act, and purporting to be signed by a person who should issue the certificate by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activities. So we can give a person who occupies a responsible position or a person in management of the activities. Now that has been changed, and it runs now like this, and purporting to be signed by a person in charge of the computer or communication device or the management of the relevant activities. That means, suppose if it's a clerk who is in charge of a computer, he can issue a certificate. Or the manager who is not actually in charge, he is in management of the activities, he can do. So that change has been made. Now there is nothing much. There cannot be much difference of opinion about it. So under subsection 4, who should have issued a certificate? The person in charge of that. Only one certificate is contemplated. Now under BSA, subsection 4 says, by a person in charge of the computer management of the activities and an expert. What does it mean? Every secondary evidence of an electronic record should contain 2 certificates. One by the person in charge of the computer management of the activities and the other by experts. How? No. Expert, who is an expert? A person skilled, special skill on that, right? The person should have special skill, and you will get these experts in technical, software matters, every you can go now. You will not get it. You will not get it. Suppose you purchase something at the cost of 1,000 rupees from a department store, supermarket. You want to file a suit. You will not get the certificate from that supermarket. He will not give you a certificate because that will be an evidence against him. So that means you have to produce it. And Who should give that certificate now? One, by that particular person, who may be an agricultural worker, he may be a load worker, he may be a coolie. He has to give a certificate now. Sorry, person who is in charge. The other one is a different one. The person who is in charge of he will not give you. Then, in addition, there should be a certificate by the expert. What is the cost of this thing? 1,000 rupees. You are filing proceedings against him, either in the consumer forum or in a court. And you have to find out as an expert. You have to pay him money. And you have to bring him for giving evidence. Then, in his examination, if he has to prove himself that he is an expert. What a cumbersome procedure now. So, unless it is read as or, practically it is impossible. Because you will not find across an expert in every nook and corner in the states. Right? Okay. So, that is the difficulty there. It maybe should be read as or, I think, or the Supreme Court will have to wait till the Supreme Court pronounces the judgment like this Arjun Patitrao. Now, so we have seen that. Now, section 61. It is the starting one, the first provision. Nothing in this adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it's an electronic or digital record, and such record shall, subject to section 63, have the same legal effect, validity and enforceability as other documents. So, section 61 speaks of electronic and digital records, right? And it becomes admissible subject to section 63. That means secondary evidence of an electronic record or a digital record can be admitted in evidence only if section 63 is complied with, right? You read section 63. It speaks of only electronic record. There is no mention about the digital record. Though section 61 says that admissibility of a digital record also is subject to section 63. Section 63 does not mention digital records. So, how can you prove secondary evidence of a digital record? It is impossible. It is impossible now. I don't know whether it was conscious or not. But since section 61 says that it is a subject to section 63, it should have found a place in section 63, digital record also. But it does not find a place. So, section 63 is not in conformity with the section 61. Now you come to, and as you all know, secondary evidence is called, secondary evidence of this electronic record is called computer output. Computer output. What do you mean by computer output? Something produced by a computer. Something produced from a computer. Just like a baby born of a woman coming out of that womb. Right? So that alone is called a computer. That is alone is called a computer output. It is only a secondary evidence. But it may have different forms. It may be in the form of printout, just like the bill we get from the supermarket. It may be in the form of a CD. It may be in the form of a pen drive. It may be in the form of a memory card or something else. Any form. But it becomes a secondary evidence or it becomes a deemed document when a computer output is not, is a computer output a deemed document? A computer output is not a deemed document unless it bears the certificate. So, a computer output without such certificate is not a deemed document, right? And how the certificate should be, what should be the nature of the certificate? Subsection 4 says, the last part, the last line, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it in the certificate specified in the schedule. So, certificate is specified where? In the schedule. That is the significance of the schedule. See the schedule now. There are two forms, Form A and Form B. Part A and Part B. See the first part, Part A, below that. So it is a certificate meant by Section 63(4)(c). At the top you can see prescribed one. See Section 63(4)(c). That is the one we have already mentioned. Okay. Part A. Who should give it? To be filled by the? Does Section 63(4) say that it should be given by a party? It should be given by person in charge of the computer or the management of the activities. But the specified this form says that it shall be given by the party. So it is not in conformity with the provision. It's not in conformity with the provision. So, and is it practically possible for the party to use such a certificate? See, what should be the contents? The last part you see. Last part. I state. So I state that the hash value of the electronic or digital record is dash. So what should be the certificate state? The certificate given by the party should show the hash value. Is it possible for anyone who is sitting there? You are all practicing advocates. Anyone who is sitting there to say what is the hash value of a document, electronic record? It's not possible for us. Still, the law says that it shall be given by the party. So it is impossible to comply with this provision. It cannot be in the form prescribed in the schedule. And remember that we have already seen that Section 63 mentions only electronic record and not digital record. But here again the certificate says electronic record or digital record, as if Section 63 is applicable to both electronic and digital record, right? Absolutely wrong. So it is not in conformity with the provisions in the statute. The form of the certificate prescribed in the schedule is not in conformity with the provisions in the Act. And the other one is to be filled by the party. Again, electronic or digital record. Again, Section 63 does not speak of digital record. So it is impossible to comply with these directions. Then how can you prove it? How can you prove it? So in almost all the cases, including civil cases in future, electronic records will be there. Electronic records, especially in all sessions cases, almost all sessions cases, there will be electronic records. It will be impossible for a party to prove electronic records because it's impossible to comply with the directions in the statutes. So that is the result or the impacts that has been made by the changes that have been made in the BSA on the ground of this software revolution. Okay, so I don't know what will happen in future in the trial courts, and first it will come to you advocates, then it will come to the courts. So how will you prove it? It will be impossible for you to prove it because you cannot comply with it. Then what the court can do? Helpless, unless the matter reaches the Supreme Court and the Supreme Court gives an authoritative pronouncement, and that will take years. By that time, much damage will have been done. Right? That is our fate now. Changes that have been made. Okay. So now we come to, these are the only changes made in the BS or the Indian Evidence Act. Now we will come to any question. അത് എക്സ്പെർട്ടില്ല. അതായത് ഞാൻ പറഞ്ഞ എക്സ്പെർട്ടിനെ കൊടുക്കണമെന്ന് പറഞ്ഞു, രണ്ടും കൊടുക്കണമെന്ന് ഞാൻ പറഞ്ഞില്ലേ. 2 certificates will be there unless it is read as all. Yes, See, how can we state all these particulars? A poor man, not even an educated man, even an engineer, unless there is an app now. I think I am told that there will be an app. Eh? Ah, 65. Ah. This is the rule of evidence in the Evidence Act. To make it admissible, this has to be complied with. That is the problem.
ഡിഫറൻഷിയേറ്റ് ചെയ്യുന്നത് എപ്പോഴും മനസ്സിലായിട്ടില്ല സർ.
മനസ്സിലായില്ല. See,
ഇലക്ട്രോണിക് റെക്കോർഡിൽ
see, in the Indian Evidence Act, the word document is used in the sense that the original document. Original document. Though the word original does not find a place in the act except in certain situations, it should be read as original document. Because what does it mean? Even section 62 says that the primary evidence, section 61 says, what does it say? 62 says what? It is the document itself. There are other sections which says that the document itself, that is the document. That means the original document. Okay? No secondary evidence is a document. It is only secondary evidence of the document. I have discussed this aspect of this matter in 2 articles written in KSC. So a document is always an original one. And a document is just like a human being. And secondary evidence, a copy, is just like a photo. A photo is not a person. A photo is only a photo. It is only an image. Right? So the document means it is just like a human being. And copy or secondary evidence means it's just like a photo, it is only an image. It does not constitute a document. Right? Likewise, in the case of electronic records, the one which comes into existence for the first time is the electronic records. Any copy, stored, transmitted, etc. It is not an electronic record, it is only evidence of a secondary electronic record. Right? That's why the word created is used there. When you create a document, after you create a document, if it is stored in another place, then it becomes, or it is a copy is taken or transmitted to another one, it becomes a copy of the electronic record, evidence of the electronic record. It is not an electronic record. But in ordinary parlance, it is also an electronic record. But in law, it is not an electronic record. It is only an evidence of an electronic record, just like a person's photo. Right? That is the difference. Electronic record and secondary evidence.
സാർ സിനാറിയോ പറയാം സാർ. ഇപ്പോൾ ഒരു ഇമെയിൽ നമുക്ക് റിസീവ് ചെയ്യാണ്. ഒരു ഇമെയിൽ നമ്മൾ റിസീവ് ചെയ്യാണ്. ആ റിസീവ് ചെയ്യുന്ന നമ്മളെ സംബന്ധിച്ചിടത്തോളം ഇൻബോക്സിൽ വന്നിരിക്കുന്ന ആവശ്യത്തിന് ഒറിജിനൽ റെക്കോർഡ്. അതെങ്ങനെയാണ് സാർ നമ്മൾ മാർക്ക് ചെയ്യുക?
See, when you receive a mail from one, it will, if you produce this email there, suppose it is a mobile phone. If you produce that mobile phone, that means the one you receive is the original one, so far as you are concerned. And there is, I mentioned section 88 in the Indian Evidence Act. Presumption as to telegraphic message has now been omitted. But 88A in the original Indian Evidence Act, and which is corresponding to section 90 now. ഞാൻ വായിക്കേണ്ടതാണ്, ഞാൻ വിട്ടുപോയത്. 90. This is very relevant, though this will be relevant in many cases now. Corresponding to section 88A, the court may presume that any document purporting to be a certified copy of any judicial, presumption as to electronic messages. Court may presume that an electronic message forwarded by originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer for transmission. What does it mean? Suppose a person's daughter, there are 2 daughters for him. One is married, the other is not married. Both of them are residing in a hostel. And one gives birth to a child at the hostel. The hostel warden sends a message to the father. The married one is called Meena, and the unmarried one is Beena. The message received was Beena gave birth to a child, and the father actually what happened? He was contested. My daughter is not married, and she has given birth to a child in the hostel. Is there any presumption? Is there any presumption? There is a presumption that was the message that was sent by the person concerned. What was received was the one that was sent. That means in the intermediate stage, in the course of it, no changes take place. The person who sent that particular message only. Nothing has gone wrong on its way. But there is no presumption that it was sent by the person who is purported to have sent it. That's what they say. See, in many cases, the prosecution will produce emails, etc., from the computer of a particular person, and they will argue that it was sent by him. See, what does it say? But the court shall not make any presumption as to the person by whom such message was sent, because using my phone, Mr. John Varghese or Tanya can send a message. So merely because the phone belongs to me, there is no presumption that it was sent by me. That has to be proved by the person who relies on that electronic message. He should prove that it was sent by me. Sometimes there may be a presumption that since it belongs to me, without my knowledge it will not be sent under section 140. Otherwise, there is no presumption. So this section says that there is no presumption. The court shall not draw an inference like that. So in Sessions case, in many cases, this provision will apply. So we should be always bear in mind that there is such a presumption and there is no such presumption as to the person who sent it, but only with the message that was sent it. Okay. Now there are some special rules of evidence in Indian evidence. BSA also. BSA also. Other thing must have been taken through those provisions. Some special rules of evidence in the BNS, just like in the CRPC also there were some presumptions. Rules of evidence, just like 162, 292, 293, etc. You are taken through those provisions, so I need not elaborate on it. I will leave it there. Okay. Now we come to the Indian Penal Code, which is otherwise called BNS. And one thing I want to bring to your notice. Section 336 of the BNS. A new provision is there. 336 rule of evidence is there. That is evidence of public servants' aspects by successor in office. Right? What does it mean? Suppose the Mahasar was prepared by Inspector of Police at Angamali, the closest one here, and when the case came up for trial, he was transferred to the nearest station, that is Aluva, or say Nedubashiri, from Angamali to Nedubashiri, that's the police station. And when summons is issued, the court was informed that the particular officer has been transferred to the Nedubashiri. Nedubashiri, the police station may be closer to the court, but he has been transferred from Angamali, right? Then what does this section say? It is sufficient to examine the successor in office. So the person who occupies the seat of this inspector now at Angamali, he alone can be issued a summons. it is sufficient that he is examined, right? Does it go with common sense? Is it possible? Does it serve any purpose? No, forget. But no, the section says that no condition is just like section 32. Unlike section 32, no condition is mentioned. If he is not available, etc. No, it is not like that. He is available, but he has been transferred. That is what section 336 says. If he is transferred, that etc. etc. Where is it stated? And it is produced before the court. Produced before the court. It is available before the court. See, the difficulty is not like that. He can be examined. There is nothing wrong. It is very easy. Huh? Yes. Here, the person is there. So issuing a summons to another person is to may cause delay. He can come tomorrow. Okay, subject to that, say it is the condition. What is it? If he is examined, assume that it will cause some delay. Assume. What is the purpose of examining him? See, Mr. Baby, can it be proved? Is there any provision for proof of that document in BNSS? In BNSS? There is no provision. The provision you will get in Evidence Act, old section 67. What does it say? Only a person, so only by proving the handwriting or the signature, you can prove the contents. Suppose the new fellow there, he has no idea about this signature or handwriting. What is the purpose of examining him? There is no purpose. No purpose will be served by his examination. If it is a matter which cannot be, if it is a matter or if it evidence does not prove the contents, what is the fun in marking it? It can be marked, but it won't serve the purpose. Marking is one thing and proving is another thing. So it can be marked, but the contents will not stand true. So it does not serve any purpose. That is the problem. So if you do it, if the prosecution does it, what the advocate should do, that person is different. Section 32 or section 32 clause 2 is there. It's very easy because he is dead. Non-availability of the witness. Only on the grounds stated in section 32. Right? It's a different thing. Here he is available. He is there. Okay. Suppose he is at Trivandrum. See, baby. Suppose he is at Trivandrum. It is difficult it is inconvenient for him to come to because it will take days. But here the next man is at the next door. Right? It saves time. But it won't serve any purpose. See? Okay, he says that it is inconvenient for he is on Sabarimala duty. See, what is the fun in examining the successor in interest? I hope you did not understand the problem. See, what is it to be examined? What is to prove the document? To prove the contents of the document. Who can prove the contents of the document? Only the person who is competent to prove it under section 60. A person who has seen him sign it. Under section 45, aspect. Under section 47, who is acquainted with the signature. Right? If he does not come under any of these categories, how can we prove it? Which condition? With what are the conditions? Right, transferred. I mentioned that only transferred. Other one you did, died, etc. right? That was there in section 47 also. Section 47. Right. That is why I told you that. That's why I told you that the person who prepared the document is on Shabarimala duty. And you have to cross this such file. And the investigating officer says that, yes, the next man is there. Examine. We can avoid delay. Section will apply. But what purpose will it serve? Unless he is competent to prove that document, no purpose. No, section 32 is different. Section 32 is different. That speaks of something else. Some more things are there. Section 32, non-availability of the witnesses for the reasons stated in it. Right? Okay. But this is entirely different. Even then, what will happen? Who can prove it? Even section 32, who can prove it? Only a person who is competent to prove the document. Here, this person may not be competent. Unless section 336 can be invoked. But the person who is to be examined should be competent to prove it. If he is not competent, merely because he happened to be the successor in office, what is the purpose of examining him? No purpose will be served. And in such cases, the prosecutor suppose examines. That is the question before us. What the advocate should do? You should not cross-examine him. And at the argument you can say, yes, this is marked, but this is not proved. Right? That is what I said. That is what I want to tell you. If that is invoked and the prosecutor proves the prosecutor gets a document marked in the section 336 and the witness is not competent to prove it, mere marking does not prove it, and you can argue that yes, it is marked, but it is not proved. Okay, you need not object to the examination of that witness. Yes. Okay. So, why should you object to the marking? Why should you say, see Mr. Michael, if you object to it, what happens? He will summon the other man. Okay, I will summon the other man. Here it is marked, he is satisfied. And the matter comes up for hearing, then you say that, yes, it is marked. Oh. Can do it? No doubt. That also you can do. You can always rectify a mistake. But that is not wise for an advocate to do. But that's not wise for an advocate to do. Mr. Baby, it is not wise for an advocate to do it. No advocate should do it. He should not raise an objection. Let it go. Right? Yes. Now IPC, only half an hour left for IPC. IPC. Certain, we don't have much time for introduction. So without any introduction, we will go to this BNS. BNS. Okay. Certain offenses have been omitted. Certain offenses have been omitted. And certain sections have been omitted. And many sections have been clubbed. Many sections have been clubbed. So I don't want to give the list of the all the entire list of these omitted provisions or clubbed sections. Some notable omissions. Or before that, there's some modification in certain definitions, etc. See, section 210, gender. And under the IPC, only two genders, male or female. Now there is a third gender called transgender. It is defined in the Act governing them. It is not defined in the BNS, but it is government. Then another one is document. The document is defined separately in the BNS, and there is an explanation to it, which you do not find in BSA. It's not of much consequence. Then another modification is in the case of the categories of classes of punishment, section 4, one punishment is added, that is community service. So you must have discussed it in the morning or yesterday. Okay, but it is a very effective punishment, and it is a punishment prescribed only in 6 sections. 6 sections matrame this punishment is prescribed this community service. How it is effective? How it is effective? More effective than punishment of imprisonment or punishment of fine. Hmm? No. Suppose you are a very rich man, you are the richest man here. Advocate Michael is the richest man in Kerala. And suppose the magistrate gives him a punishment. You pay 1,000 rupees. What will you do? Hey, what is this? 5,000 rupees. They got it. It is not a punishment for him. A punishment should always be painful. Unless it is painful, it is not a punishment. So it is not painful for him because he is the richest man here. But suppose the magistrate orders, you go and sweep this road in front of Kerala Judicial Academy for 1 week, is a punishment for him. Right? Or you go to the district hospital and serve there as a bystander with patients, the richest man. And this is applicable to the young people whom we call or we dub as ഫ്രീക്കന്മാർ നമ്മുടെ മലയാളത്തിൽ അല്ലേ? വലിയ സ്വർണ്ണമാലയൊക്കെ ഇട്ട് ഷൂസും ഒക്കെ ഇട്ട് ബൈക്കിൽ ചെത്തി ഇറക്കുന്ന പിള്ളേർ അല്ലേ? അവർക്ക് ഇതൊരെണ്ണം കൊടുത്തു കഴിഞ്ഞാൽ എങ്ങനെയിരിക്കും? നിങ്ങൾ ആ സെന്തരാസ് അസ്മാനത്ത് ആദ്യം പോയി നിന്നിട്ട് നീ ഒരു കാര്യം ചെയ്യും, നീ എല്ലാ ദിവസവും അവിടെ ആ മരത്തിൽ നിന്ന് വീഴുന്ന ഇല എന്നും നീ തൂത്തുവാരി കളയണം. മനസ്സിലല്ലോ? തീർന്നില്ലേ അവന്റെ ഫ്രീക്കൻ പണി അല്ലേ? So it is more effective than the other punishment, but I don't know, it is prescribed only in 6 cases. Okay, forget it. Now what are the offenses omitted? One is section 124A, that is the sedition. Several provisions have been omitted. Then the other is section 309. Section 309 is the attempt to commit suicide. But there is a new provision, that is section 226. It has nothing to do with the old 309. Section 226. Whoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty shall be punished with single imprisonment for a term which may extend to 1 year, or with fine, or with both, or with community service. The punishment prescribed is only 1 year, and it is a non-cognizable offence. Going by the schedule, it's a non-cognizable offence. The police cannot arrest him unless it is committed in his presence. Even then, he can arrest him. There is nothing wrong in it. Okay, so when does this offence or this provision apply? Whoever attempts to commit suicide with intent to compel, forget the word or restrain, compel any public servant from discharging his official duty. When does it apply? Suppose, not a compel, to compel to do something, a positive act. Suppose the power supply in my house failed and there was no response from the electricity board for 1 week, and I go to the electricity board and says that I will commit suicide. I am pouring water on my body as if it were kerosene oil. And they will immediately say, oh, he is committing suicide, compel us to give restore power supply. It becomes an offence. It becomes an offence because he attempted to commit suicide to compel the electricity board to restore supply to his house. Not only that, he will not be the power supply will not be restored, he will face the prosecution also. Of course, it is a complaint disorder. Complaint disorder because it is not cognizable offence. Okay. So another case you take. Now there are this threat of this wild animals. in high ranges, Idiki, and other places also, even in Iran, like that Malayadu or that area. And you are compelling the revenue authorities or the forest officers to kill these animals who pose a threat. And there is no response. And one of the residents said that I am going to commit suicide, and he does something in its attempt to do it, and this offense will be attracted. Take the case of this farmers' agitation in New Delhi. Many committed suicide, and there was attempt to commit suicide. Then all of them will be prosecuted under Section 226, right? And suppose a surface under the Surface Act, the bank officers come to a person and he threatens to, or he does something to commit suicide. He will not only lose his property, but he will land in jail, right? So, what is the object of this section? To suppress agitation. It is suppress agitation, right? People will not be free to agitate. Okay, you can say it. You can free to agitate, but not right. Yes. In Todupuzha, you can go and tell them what response you will get. You can say Idukki district. You can say it here only, but not outside this judicial academy, especially if your fellows in Idukki district. Yes, Mr. Baby. Okay, so this will be the result of this. Is the object of this section, right? And even if the public servants do not discharge their duties, we will be helpless. Because in many cases, because of the threat only, they discharge their duties, right? I don't think that it is fit for democracy. Okay, forget it. Now section, another section is section omitted, section 377. 377, as you all know, unnatural sex. Why the Supreme Court struck down? Did the Supreme Court strike down section 377? Only a part of it. The reason stated by the Supreme Court is that because of consensual sex between two adults in privacy is not an offense, right? Because you have autonomy over your body, right? But without consent, suppose a male person subjects another adult male to sexual intercourse, is there any offense now? Rape? Only between man and woman. 323. എനിക്ക് വേദനിച്ചു മനസ്സിലല്ല ഷോ എത്ര ludicrous ആണ്. This is ludicrous. And between man and or beast, it happened here in Peribau 1 month ago. There is no offense now. Yes, this is the result of this omission of this particular section. Forget. Then 497. Adultery. You are free to commit it if your wife has no objection. Why did the Supreme Court strike down 497? Because gender bias. Only one sex is prosecuted, the other sex is not prosecuted, though they commit the same offense. Right? Now, the government, the parliament says that you are free to do it, irrespective of your sex. Nothing wrong. Okay. Now you see some new offenses are there. Identical provision. I have not come across a provision. എന്താ പറയുക? അത് പിടിക്കാം കേട്ടോ, അത് പിടിക്കാം. അയ്യോ, ചിന്തകൾ എത്ര വേഗമാണ് പോകുന്നത്. ഞാൻ അത്ര അങ്ങ് ചിന്തിച്ചില്ല കേട്ടോ. Yes. You are a visionary. Yes. Now section 48. Section 48 we have seen territorial, outside the territory. You have seen the amendment made in Evidence Act. Section 48, abetment outside India of offences in India. Because of the globalization, as a result of this software revolution, one can commit, you can abet commitment of particular offense sitting in America. He is in America, but he can abet a person to commit an offense in India. Especially, you know that what happens in this media, right? So such thing is now attached to section 48, that abetment outside India of an offense in India. Section 48, it depends upon the offense which was abetted, whether it is a court of session or magistrate court. Then section 69, preventing. If abetment is there, it can be done. Then this will first 48. But we'll come to section 48, the another section later. Then section 69 is very dangerous. It's very dangerous, section 69. What does section 69 say? Section 69, you read, there is no, do you think that there is no gender bias? 69. Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same, the sexual intercourse with her, such a sexual was not amounting to the offense of rape, shall be punished with imprisonment of 5 years information to 10 years. It's a very serious offense now, right? What are the conditions now? The first condition is that there is, the act does not amount to rape. What does it mean? It is consensual sex. The sex should be between man and woman. Whoever by deceitful means or by making promise to marry to a woman. So man, the promisor is a woman, man. The promisee is a woman. Without any intention of fulfilling the same, has sexual intercourse with her. So the third one is that he made a promise that he would marry her, or the consent was obtained by deceitful means. Deceitful means. And he is a married man, but he suppresses it and he says that I am a bachelor, I will marry. Okay. Or even without that. Okay. Or by making a promise to marry to a woman without any intention of fulfilling the same, has sexual intercourse with her. What is the danger in it? I have already told you that the changes that are being made in a statute reflects what? The changes that have taken place in the society. Section 69, it reflects it. What does it reflect? Reflect who will be the victims of it. Eh? I think you are conscious that at least 35% of our youngsters do not believe in the institution of marriage now. They do not believe because it is a burden for them. They cannot enjoy the family because children, they are a burden for us. So they do not marry. At the same time, they have to satisfy their biological needs. So what happens? You can see if you go to Wayanad, you can see at the weekend there will be a rush of boys and girls from Bangalore. Right? They enjoy themselves. And there will be no marriage. Suppose the boy refuses, the man refuses on one occasion, and the girl is aggrieved, he will invoke section 69. That once you are trapped, that means you are trapped forever. Right? So that is the danger in it. That is the danger in it. That is true. The Supreme Court brought it under section 376. Yes? That is true. Now the risk is more. Then it was very difficult to prove. It was very difficult because the Supreme Court brought it under Section 376. That is, consent was not valid consent on a false promise of marriage. Right? That was the Supreme Court. Now there is a separate offense. It forms a separate offense, very dangerous, and many of our youngsters will land in jail. There is let it act as a or interim. Okay. Yes. Now Section 73, printing or publishing matter relating to court proceedings without permission. Any magisterial offense. 95, hiring, employing or engaging a child to commit offense is a juvenile act. 103, it corresponds to Section 304. Sorry, 302. ഇനി മുതൽ 302, 420 ഒക്കെ ഇല്ല അല്ലേ? പണ്ടെല്ലാം അവന് 400 ബീസാണ് ഹിന്ദി പറഞ്ഞ അതിൻ്റെ അർത്ഥം എന്നാണത്, അവൻ ഒരു ചീറ്റാണ്. ഈസ് എ ചീറ്റ്. 400 ഫ്രോഡ്, 400 ബീസ്, 420 ആണ് അല്ലേ? ഇനി അത് പറയാൻ പറ്റില്ല, ഇനി അതിന് അർത്ഥമില്ല അല്ലേ? 302, that was the section which everyone knows in India. 302. Now it is Section 103. And 103, suppose that offense is committed by a crowd of 5 or more persons, unlawful assembly, the old unlawful, it is now a separate offense. It is called lynching. അല്ലേ? ആൾക്കൂട്ട കൊല, അത് separately taken care of. Murder by 5 or more persons, lynching. Then 106 is a new offense to some extent. 106 2, but that is not notified. But 106 there is a change. That is the 304. There is a change. 104 it was a common provision for everyone. No particular section of the society had been carved out under Section 304. Any person who commits or causes death by rash or negligent act was liable. What is the punishment? 2 years. 2 years or fine. Now it is 5 years and fine. Okay, it is very fine. But that is not applicable to a doctor. And doctors, there is a specific provision. What is it? There is a concession. Discount their blood. That is, here they will get only 2 years and fine. Again, and fine. The doctors are aggrieved because we have to undergo imprisonment and give punishment. We should have been restricted to fine only. That is the argument. Right? But remember that, whether it's a common man or whether it is a doctor, negligence here means what? Gross negligence. And commonly it applies to doctors. Okay. In driving, suppose you cause the death of a person, there is no question of gross negligence or something like that. It is always negligence, right? But this particular phrase, gross negligence, always applies to doctors. They get the benefits, right? And in what cases gross negligence will there? And you know that 2 months ago, a mother went to a hospital with her child. He had some problem. He had a 6th finger, and for a removal of it. And which part of his body was operated upon? Tongue. The doctor thought that it was a tongue-typings. And thank God that the tongue was not removed. And the doctor admitted his guilt. Should he be not punished under the criminal law? Because it is a no gross negligence. How can these doctors object to it? And Alapura, what happened? Instead of operating upon the right lung, the doctor operated upon the left lung. Should he be not punished? He should be punished. So, I think the doctors actually got a benefit. And there is no room for, they did not feel aggrieved. Only 5 or 6 minutes. Okay. But when you come to Section 106(2), hit and run case. And the punishment is but it is a magisterial offense. It's a magisterial offense. Okay? And what is, and it is not notified. It's not notified. Thank God. It is not notified. Because, see, but read the section. What does it say? Eh? Whoever causes death by Allah, rash and negligent action. അത് മുകളിലുള്ള സാധനമെങ്കിലും ഒന്ന് വായിച്ചിട്ടെങ്കിൽ പറ്റുമായിരുന്നു. At least that means the person who was not conscious of the provision there. One note, the first part, subsection says that rash or negligent. Here it is rash and negligent. How can a person be rash and negligent at the same time? If he is rash, he is not negligent. If he is negligent, he cannot be rash. Right? But it has not been enforced. Okay, notified. Then, section 111, organized crime. Organized crime. Organized crime. Though this was not all over India in this penal code, this offense was there in some states like Maharashtra, where this Mocha Act was there. Maharashtra organized the crime. Yeah, it was there, almost the same thing. But yes. So here some phrases are seen, organized crime. That means there should be an organized crime syndicate. Cyber crimes are trafficking for policing any person, group of persons acting in concert singly, either as a member of an organized crime syndicate or on behalf of such syndicate. So there should be an organized team. And why it is used that either singly or jointly? The act may have been done by one person, but that is organized by the organization, this gang, or on behalf of them. It is sufficient for one man to do it. So he did it singly. Even then it becomes an organized crime. And then any continuing unlawful, what is a continuing unlawful activity? This is different from continuing wrong. Continuing wrong is an idea in law of torts. Law of torts. And continuing, if it is a continuing wrong, you get cause of action, new cause of action, every moment. But this is not a continuing wrong. This is continuing unlawful activity. And it is defined. Means any activity prohibited by law which is a cognizable offense punishable with imprisonment of 3 years or more, undertaking by any person, either singly or jointly, or as a member of an organized crime syndicate on behalf of the syndicate, in respect of which more than one charge sheets have been filed before a competent court within a preceding period of 10 years, and the court has taken note. So, what is the condition? A charge sheet should have been filed against him, minimum 2. The time space, 10 years. And this does not say that, so it should have been taken cognizance by the court. It does not say that he should end in conviction, or even if he was acquitted, this section will apply. This section will apply. That is the special feature of this section. Even in the case of acquittal of the previous cases, can be proceeded against under section 111. Okay, this is good because of the present activities in our society. Now we come to petty organized crime. That is meant for my states. See, whoever being a member of a group or gang, either singly or jointly commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers, or any other similar act is said to commit any petty organized crime. That is meant for my states. Right? Okay. See, I have already told you that The new law will reflect the changes in society, the developments in the society. Here you can see unauthorized selling of tickets, unauthorized selling of railway tickets, right? It has now been made an offence under the present IPC, we can say, BNS. And selling of public examination papers needs, right? Need this had no place in 1860. Yes. Then there is a danger in this provision or any other similar criminal act. This is a phrase which should not be included in a penal provision because it is bad for uncertainty. What is the similar act? Nobody can say. Nobody can say. So any other similar criminal act that is very dangerous, it is left to the discretion of the magistrate. That means it is uncertain. It is uncertain. Such a phrase you should not find a place in a penal provision. Penal provision. Okay. Now we come to section 113, Terrorist Act. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, sovereignty, security or economic security of India. That is we have no dispute about it, or there need not be any interpretation or comment on it. Or with intent to strike terror or likely to strike terror. It is not intended, but it is likely to cause terror in the people of any section of the people in India or in any foreign country. So, what are the acts? By using bombs. It's sufficient that one bomb is used. And there was a dispute whether blasting of bomb comes under this UAPA. Justice K.T. Shankaran expressed the opinion that it will come. Now that uncertainty has been removed and says that just using a bomb will attract or will become a terrorist attack. Right? It is a terrorist act it is now. And in Kannur, Thrissur, Kozhikode, there was bomb blast within a space of 2 or 3 months. Right? So all these are considered terrorist acts. And even if it was not intended to create any terror, it is sufficient that it is likely to cause terror that the section is attracted. Right? So here blasting of a bomb, will it not create terror in you? Yes, it will create. Say a very bomb blast, using of bomb that will attack section 113. It is a sessions offense trial, and for want of time, we need not discuss it now. Now there is another section 304 snatching. 304 ministerial offense, new offense. Theft is snatching. What does it mean? You will see similar provisions penal provisions in the Indian Penal Code. Extortion, robbery, dacoity, etc. Right? So in it there is theft. So here also there should be theft. Theft is snatching, there should be theft. Unless there is theft, there is no question of snatching. So see, there is a difficulty in it, interpreting it. In order to commit theft, the offender suddenly or quickly or forcibly sequesters or grabs or takes away from any person or from his possession any property, any movable property. So, what acts amount to snatching? The first words, theft is snatching, means theft has already taken place. Unless theft has taken place, there is no question of snatching. That is the impression that this phrase will create. Subsequently, it is said that in order to commit theft, that means for the purpose of committing theft, what he should do, the offender, suddenly or quickly or forcibly seizes or sequesters or grabs or takes away from any person or from his possession any movable property. Suppose I have some cash in my pocket, and to so that others may not notice it, I put a handkerchief above it, and I am on my way to entering a bus or train, and somebody just picks it, and he gets only the handkerchief. My cash is there safe. It is safe there. Does it amount to snatching? Yeah? He has removed something. Suppose he does it slowly. What does it say? It should be done suddenly, quickly, grabbing, etc. Suppose he does it, eh? Takes away, right? Or grabs or takes away. എങ്ങനെ? Quickly or forcibly seizes or secures or grabs or takes away from any person or from his possession. So he removes only handkerchief. Eh? That is snatching, right? Then theft is snatching. He had no intention to commit theft of my. He had no intention to commit theft of my handkerchief. He had no intention. Huh? That is true. Okay, that will come to attempt to commit theft. Okay, there is nothing wrong in it. So if snatching is amounts to theft, then what's the difference between this 303, the other one? Okay. Whoever commits theft shall be punished with imprisonment by the which may extend to 3 years. Here also it is 3 years. Okay. Or with the fine, or with both. Here, okay. Which may extend to 3 years and shall also be fine mandatory. That's the only difference now. That's the only difference now. Okay. Which shall not be less than 1 year, but which may extend to 5 years or with fine. That is there. So, the court can award subsequent conviction. Otherwise, it is or with the fine or with both and the second is. Right? Same. What is the fun in having such a provision? What is the fun in having such a provision? Waste of time and money? That is the problem. Now see, there is another provision. In subsection 303 theft, 2 proviso is there. Provided in that cases of theft where the value of the stolen property is less than 5,000 rupees and a person is convicted for the first time, shall upon return of the value of property or restoration of the stolen property shall be punished with the community service. Here remember, the only punishment is community service and that is mandatory. The only punishment prescribed is community service and that is mandatory. Right? Okay. So, how can it be applied? Provided that in cases of theft where the value of the stolen property is less than 5,000 rupees and a person is convicted for the first time. So, when does this question arise? When does this question of application of this proviso apply? Only after conviction. That means after conviction, he returns or restores the property or the value of the property. Then this proviso will apply. Right? Okay? So he must have already committed theft. And what does the BNS say? This is a non-cognizable offense. How can it be worked out? Only after conviction this question arises. But that has been made a non-cognizable offense. So the offense actually he committed is theft. Even if the value is 5,000 rupees or less. It is a theft under section 303. So actually this is what can we do? What can we say? Illogical. It is illogical to say that this is a non-cognizable offense. So to that extent also, this is not in conformity with the BNS is not in conformity with the BNS. Okay. So these are the changes that have been made, and these changes reflect the mood of the society now. Then there are only 6 provisions which attracts community service. Section 202, Section 209, Section 226, 303(2), 355, and 356(2). Then some changes in this penology or victimology. The concept of victimology has been introduced now. To some extent, it was already there, but it has been extended now. And under Section 357 CRPC, the magistrate or any other person could award of sentence, and out of it fine, and out of it pay compensation. Right? Now, any amount out of it, compensation can be made. Now it is said that fine shall be paid to the victim. If the court imposes fine, the entire amount shall be paid. It is mandatory, no discretion for the sessions judge in cases of rape and gang rape. Sections 65 and 70. Fine is mandatory, and the entire amount shall be paid to the victim. And how this fine can be determined? Medical expenses and rehabilitation of the victim shall be taken into account, and the fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. Okay, medical expenses, it is very easy for us to understand. But what about rehabilitation? Rehabilitation means, suppose you know that in every case of rape, the victim, there is a stigma attached. There is a stigma attached to the victim. Oh, it's a victim of rape, as if she committed the offense. This is the impression we get, or that is the standard of our society now. That means she will not be comfortable in the society. So she has to remove herself from the society which knows her. And that means it is necessary for her to change her place of residence. And he has to find out a new place of residence. That means rehabilitation. So the amount that may be needed to find out a new place of residence also shall be realized from the accused. In America, in serious offenses which cause threat to the security of the nation, naturally, very serious offenses, no witnesses will come forward to give evidence because there will be threat after the trial also. What they do? They change their, and they will do some plastic surgery. They will change the physical features, and they will give him a new name and a new passport, and give a place of residence far away from here. Right? That concept is now introduced. So whatever is necessary for rehabilitation, the court can take into account and award costs. It will be paid fine. That will be paid as cost for medical expenses and rehabilitation. That is the concept that has now been introduced in the many sections have been clubbed, especially unlawful assembly sections, all clubbed. Kidnapping, cheating, all have been clubbed. Then some sections have been split up. So for our present purpose, I think this is sufficient. It is 5:15. So thank you very much. Don't think that this is an exhaustive study. This is not an exhaustive study. This is all what I can do in this limited time.
ഡൗട്ട് സാർ നമ്മുടെ 69-ലെ അല്ല ഈ ബർഡൻ ഓഫ് പ്രൂഫ് അത് ഒരു വിത്തൗട്ട് എൻ ഇന്റൻഷൻ ഓഫ് ഫുൾഫില്ലിംഗ് ദ പ്രോമിസ് എന്ന് പറയുന്ന ഭാഗത്തെ അതായത് ഒരു ബർഡൻ ഓഫ് പ്രൂഫ് അപ്പം അത് ശരിക്കും ആരുടെ നല്ലതായിരിക്കും അത് പ്രോസിക്യൂഷന്റെ ആണെന്ന് മാത്രം പറയാൻ പറ്റുമോ?
See, subject to exceptions, the burden is always on the prosecution in criminal cases, never shifts. Right? In the case of consent, in rape cases, other sexual offences cases, you know that there is a provision that it is sufficient for the victim to say that there was no consent. That alone is sufficient. അതെ അതെ എന്ന് ആര് പ്രൂവ് ചെയ്യേണ്ടി വരും? പ്രോസിക്യൂഷൻ പ്രൂവ് ചെയ്യണം. ഇറ്റ്സ് വെരി ഈസി. വെരി ഈസി. സുപ്രീം കോടതി ഒരു കേസിൽ പറഞ്ഞു, എ ബ്രാഹ്മിൻ ബോയ്, he had a sexual intercourse with a woman. Admittedly, he had made a promise. That did. But there was no marriage. Marriage did not take place. The reason is that the entire community is against it. What did the Supreme Court say? A Brahmin boy in Rajasthan cannot believe that he would be able to marry a Harijan girl. It's almost impossible there. That means he was very conscious that the marriage will not take place. That's sufficient. ഡെത്തോ? ആ ഡെത്ത് ഇല്ലെങ്കിൽ പിന്നെ പ്രൊവിഷൻ വരില്ലല്ലോ. വേറെ മറ്റു പ്രൊവിഷനല്ലേ വരുന്നത്? ആ അപ്പം മറ്റേതിലേക്ക് വരും. 337, 338 പഴയ അതിലേക്ക് പോകും. How is it possible? All are distinct, not of the same kind. Not of the same kind, especially in criminal cases. അല്ല. Well, similar offense, similar.
When we are applying the principles of haste and canaries, apply mischief, trespass, or any other offense. That offense of same nature or similar kind of offense should be categorized under IPC or BNS. അതാണ് വക്കീലദ്ദേഹം പറയുന്നത്. നമ്മൾ ഈ പറയുന്ന ഈസ്റ്റേൺ കൺട്രീസ് സപ്ലൈ ചെയ്താൽ 149 ക്രോർ ഓഫൻസ് വരാൻ പറ്റത്തില്ല. പക്ഷെ സുപ്രീം കോടതി 2 ഡിസിഷനിൽ പറഞ്ഞിട്ടുണ്ട് offense that comes under IPC will be applicable. ഇപ്പൊ അത് ലാർജർ ബെഞ്ച് കൺസിഡർ ചെയ്യാൻ പോവുകയാണ് whether that 141 that mischief, trespass or any other offense will comes under the scope of any other offense covered under IPC. അത് റീതിങ്ക് ചെയ്യാൻ സുപ്രീം കോടതി ഷെഡ്യൂൾ ചെയ്തിട്ടുണ്ട്. In a similar way, ഇവിടെ any other acts of similar kind of that is how only we can interpret it. BNS BSA പറഞ്ഞപ്പോ see ICT is that section 61 contains almost a non-obstacle. Section 63 contains again another not-withstanding, starts with not-withstanding. Which one will provide? That is also a debatable point. Only time will tell that how we have to deal with that. So when two non-obstacle clauses of similar nature comes in a statute, then we have to apply the principles of interpretation. Then we can get another version on those kind of insertion of provisions of law. That is why we started with a caveat that this is not an exhaustive study. That today, when we dealt with 531, we put forth a one particular version. Now decisions of our own High Court has come. Now a decision of our own High Court has come in a way that what we have said in the academy is the version that is asserted by the High Court. So it has to come through the judicial decision. We have to wait for that. All these are possibilities which we have to wait and see. So, two difficult topics in a single session at a stretch. It can be done by only a master who is able to do that. Fortunately, for the same, we had Honorable Mr. Justice K. Abraham Matthew. On behalf of all of you, I express our deepest gratitude to His Lordship. And Bar Council of Kerala, it's being represented by its president and some of the members who are associated with the academy to conduct a function of this nature. I hope that the services rendered by us match to your expectations. If there is any deficiency, you can point it out so that it will be a guidance to us for our future endeavors. So I appreciate the Kerala Bar Council for associating with the academy to undertake training of this nature. There may be future endeavors from the side of the Bar Council of Kerala of similar nature that was suggested by the members and chairman. We will contemplate with that after getting due approval from the board of directors. And for you accepting our invite, you all turned up to attend the training. We are so thankful and grateful to you for attending the training and coming to the academy. Thank you. Hope that we match to your expectation again. Thank you.
Respected Justice Sri Abraham Matthew, the Director of the Academy, Sri Sujit, other directors, the Chairman of the Bar Council, other respected members, my dear friends. We are here for the last 2 days together. We were residing together. We had food together. We had a better class. We enjoyed ourselves. Of course, the credit goes to the academy for providing us such a scenario. It is because of interference of the respected chairman of the Bar Council and the aid granted by the respected director of the Judicial Academy to provide us such a class. Anyhow, the Judicial Academy, the respected director offered us to provide these type of classes at the district headquarters of every district of the state. The Bar Council is making arrangements to conduct. We hope that we will meet again in the class with the aid and class by the resources persons to be provided by the Judicial Academy at the instance of the respected director. Anyhow, we are happy that we are taught with the subject by earlier Justice Bishardi and now respected Justice Abraham Matthew, like feeding like a child by making him to sit in the lap of mother. So we are happy for that. I convey hearty regards on behalf of the Bar Council of Kerala and on behalf of everybody to respected Justice Abraham Matthew, Justice Bishardi, and the director as well as others of the Judicial Academy. Thank you all. Thank you.